Mohammed Syed. Please state your name.
Good morning, everybody. Happy
Mohammed
Tuesday.
Syed.
Welcome to TCF
Thank you. I've
Live.
had
My
the
name is
opportunity to
Dan
talk with
Soul. I
Mr.
will be
Syed,
your
Your
guide
Honor,
through
Mr.
the next
Syed, Your Honor,
3
apprise
hours
him
of our
of
journey
the
through
charges,
Portlandia.
apprise him
We'll
of the
get started with
operation
our
drive that
favorite
Royal
magistrate,
District
the
Court
grumpy
has,
magistrate
being
Chisholm.
fully informed.
The plea of not guilty does enter. The next step in the process, Mr. Syed, will be a pretrial conference. You'll be notified by mail of the conference date and time. It'll be a Zoom hearing, but won't use the same set of Zoom numbers that you're using this morning. So when they send you the notice, they'll send the new Zoom contact information. And that leaves us with bond, Mr. Dean.
Yes, thank you, Your Honor. My client is 27 years old, a resident of Oak Park. He works at a tier 1 auto manufacturer supplier on the factory floor. His cousin drives him back and forth to work. The other thing I want to point out, Your Honor, my client indicated to me that on June 10th through the summer, he's taken a position in Alaska working for a fish supplier up there during the season. So he will not, he's asking permission to leave the state. I told hopefully this should be completed by then. I think he's a perfect candidate for Operation Drive. He indicates he's never had a license. So that being said, I'm asking for a personal bond, Your Honor.
Thank you. Operation Drive is a Zoom process. So it wouldn't matter if he was in Alaska or Argentina.
Very good, Your Honor.
The Zoom works. Mr. Mohammed, Mr. Syed, the purpose of a bond is not to punish somebody before trial. It's to make sure they get here and to ensure the safety of the public pending. You're here on time. There's no reason to believe that you're not going to come back, because the candidate's in your best interest to come back, because Operation Drive works. So the bond in this matter is going to be a personal bond in the amount of $2,500. You don't need to pay money to stay out of jail till the trial. It's a personal bond. In the event you fail to appear, then you get all the money, but just show up on Zoom, and the program is going to be a benefit to you. So you're good to go today. You get the notice in the mail, and you'll stay on with Mr. Dean. Thank you.
We'll be in touch.
Your Honor.
I'll be in touch, Mr. Mohammed.
All right. Thank you, sir.
You're welcome.
Did you see a loo on the docket?
I'll look that up.
We have a bird.
I
don't see a bird either.
It might be the, oh, yeah, I'll look it up.
And Plakta. Why do we have 3 people? I don't see any of the first 3 people in the waiting room on the.
Is there a Mr. Norton?
We have a Samsung, so let's see who's behind that. Someone's come online from a Samsung. Please unmute yourself and identify yourself. What is your name?
Nathan Norton.
Say again, please.
Nathan Norton.
He's the second one on the list, Your Honor. Norton.
Nice. That's who you thought it was.
Yeah, I talked with him already. We're ready to go.
Okay. This is 26-00434, People versus Nathan Norton.
Good morning, Your Honor. Michael Dean, P32631, court-appointed attorney for arraignments today for the 44th District Court. We agree to conduct this proceeding today by Zoom. Mr. Norton, state your full name for his honor.
Nathan Blaine Heichel Norton.
Okay, can you turn your camera the other way so you're face up with us? There you go, perfect. Just stay like that. Thank you. I've had the opportunity to talk with Mr. Norton, Your Honor, apprise him of the charges, apprise him of the arraignment procedure and his rights, being fully informed, he waives formal reading, stands mute, asks that you enter a not guilty plea, and he would like my assistance as his court-appointed attorney moving forward.
You think he qualifies?
He indicates that basically he has expenses and he does have a working position, but it's possible that he does qualify. I don't know what the cutoff point is there.
Okay. So if noted, he's requested the MIDC, and that leaves us with bond.
Thank you, Your Honor. I had the opportunity to have a discussion with Mr. Norton yesterday. He's 51 years of age. He's the kitchen manager at Danny's Irish Pub on Woodward and Ferndale. He basically indicates he's not on probation or parole right now. He's a resident of Clawson, Michigan. That being said, it did indicate to him that he should be prepared to have a pen and paper because there will be pretrial services he needs to engage in terms of alcohol testing. He indicates that even though he works in a bar, he understands that he cannot drink. He indicates that he's the kitchen manager, basically prepares the food for diners there. That being said, Your Honor, we're asking for a personal bond as well as pretrial services. Thank you.
While you're on this bond, Mr. Norton, you simply cannot use alcohol at all. No use of alcohol, no use of marijuana or any illicit drug. You'll be supervised by pretrial services of Oakland County. You'll need to call them tomorrow to set up the testing. Their number is 248-451-2315. If you call today, they won't know why you're calling because your file's on my desk.
Okay.
So give them a call tomorrow. They'll do a drug test as soon as practicable. If the test is negative for drugs, then there would be no further drug test. In the event the test is positive for drugs, then in that event, the testing would continue at the rate of 2 times a month.
Yes, sir.
Mr. Dean, do you think that your client would prefer a sober link or to do the twice a week random ETG?
I think with his position and working at the sober link, Your Honor.
There is a cost associated with that, of course.
Correct. Mr. Norton, do you understand there's a sober link, which is going to cost you, I believe it's $60 a week that you would be testing on. It'd be portable that you'd have, or you would be given random dates during the week to go to a testing facility to test there. What would you prefer?
I don't understand what the sober link is.
It's basically it's a device that you're going to carry with you, like a portable cell phone that basically you'll be given an indication by a beep that you need to blow into it at that point in time, or gives you 15 minutes to do.
Okay. Yes, sir. I could do that.
Okay.
It'll be sober link 4 times a day. To be operational by Thursday at noon. That would be the 30th.
Alrighty, good morning once again, everybody. It is TCF Live on a Tuesday. Good to have you here. Apologies for the slight technical mishap we had at the beginning there. Sometimes on my stream deck, the mute button gets like flipped, and I think that I've got the feed muted, but it's actually live, so I fixed that. We're all good. Good to have you all here. I would like to call your attention to our super chat goal for today. If we hit that goal tomorrow, I will open and close the show doing a stupid Dan trick that I have, and that's to basically Dr. Seuss things. So I will Dr. Seuss my opening and closing tomorrow if we hit our super chat goal. Let's stay in Michigan, but let's go over to Judge Simpson. Early start for him today.
Chris Gaines, how are
Yes, sir.
I'm
Good morning. How are you?
doing well. Can we do the waiver, please?
Yes.
He already did that part because he was late coming in.
Okay. Joy Gaines, Senior Assistant Public Defender. Like the prosecutor's office, we too do not believe there is a conflict, but if there is a conflict, we would waive it.
And the court for its part also does not believe there's a conflict either in the Michigan court rules or the cases decided they're under. The extent of conflict does exist given the waivers, the court will. All right. Are we ready on anything you have? No. Bye. Okay.
I want to check in with Mr.
About it. With someone in tow.
Good morning, Your Honor.
Good morning. Hey, we need lunch. But we don't know what we're having because we have to wait on someone. Take care, Mr. Simon. Always a pleasure, sir. Where is everybody?
Let me define this topic.
What?
If we can,
Well, Mr. Cook's here. Ms. Feltes left. Joy's here. Who's in the hallway? Are they ready? I don't want that one. Court does call the case, People State of Michigan versus Rubinal Bay.
and Your Honor, Raymond Cook for the people.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, living on behalf of Mr. Bay. Would you please?
Good morning, Your Honor. Rubinal Bay. Good morning. I like that. The way he did. All right, go ahead. I'm sorry.
Your Honor, some people are unable to proceed.
Your Honor, we move for a dismissal.
People being unable to proceed, this case is dismissed on the motion of the defendant. All right, thank you, sir. Have a great day.
Thank you.
To say. Nice jacket. What did you say? It's not really my color. All right. What? Okay, and I'll stop talking. I'll sit here and look stoic. It can only last for a few minutes.
Ashley, thank you for the $5 and getting us started off. I very much appreciate that.
Yeah, we've heard you were saying. Oh, you need.
Okie dokie. As intriguing as Judge Simpson's court usually is, he's off to an incredibly slow start. So let's switch over to Judge McNally. We'll check back with Judge Simpson later, maybe.
To pay $249. That is one day for every $10 owed. So we could receive 25 days jail. You could satisfy that in part by payment, in part by serving the jail term, or in full by paying the amount due. You can purge the entire contempt. Do you understand that?
Yes.
Did you sign, read, and understand an advice of rights form here today?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that? You have the right to a lawyer. I'll be happy to provide you with one at public expense. Do you understand that? Would you like an attorney? To the charge you failed to pay $249, how do you plead? You failed to pay?
I won't be able to pay.
No, I said, did you fail to pay? Did you fail to pay the amount due on this? Anybody force you to plead guilty?
No.
Why didn't you come in and pay it?
I can't get it.
Why didn't you come in and pay it?
I deal with CPS.
You work?
Lost my job after that. Yeah,
Where were you working?
I was working for Amazon.
How much do you have today?
How much like a minute?
How much do you have today?
We have like a couple bucks.
$2?
I have like 4, 5. I won't be able to pay until the 26th of May. I'll be able to pay the full amount.
Are you sure?
Yes.
Next time you gotta come and talk to us when you don't have the money, okay?
Okay.
So I'll give you until the 28th to pay, okay?
Okay.
If you, May 28th, if you don't have the money, you can either come in here on or before the due date at 8:30, or you can call the court on or before that due date at 8:30 in the morning, and I'll give you an extension. Just don't ignore us, okay?
I will.
All right. Anything else? All right, good luck.
You're
Welcome.
Tim, thank you for the $2, and Nina, thank you for the $5. Very much appreciate it.
Cameron Jamal Cottrell. 25W839925. Your name?
Control.
See, now this kind of thing I don't understand. What did I just tell him? What did I just tell him? Did you hear?
Yeah, about calling me to make an extension or something.
I told you that too. When-
Yeah, I've been.
Hang on. When I gave you a payment plan on January 23rd, and you told me you could pay $50 per week beginning February 9th. You haven't paid a nickel since then, and you didn't extend the courtesy of coming in here and talking to me or calling the court and saying, can I get on Zoom with the judge? I need it. Did you? Why not?
I've been taking care of my father in Atlanta, so I've
I'm sorry?
been taking care of my father in Atlanta, so I
You've been in Atlanta for 3 months?
Huh?
You've been in Atlanta for 2.5 months?
Yes, sir.
Did you,
I just completely forgot. It just.
you
slipped my
forgot?
mind.
You know what the title of my book's gonna be? Don't tell the judge I forgot. You didn't forget it. You just kind of blew it off. And you probably haven't been in Atlanta for 2.5 months, right? You want to go get your itinerary and show me when you flew there and when you flew back?
No, I drove, man.
You drove there and you were there for 2.5 months.
Sir.
When did you come back?
A couple of days ago, my mail goes to my grandfather's house. And my aunt told me that I had a court date.
Remember when I told you you could Zoom? You could have Zoomed from Atlanta, couldn't you?
I didn't know I could.
I told you that. I tell everyone. If you want, I'll go listen to the recording right now. I know I told you that because I tell everybody that. And you didn't do that because you don't have any respect.
No, I do, sir.
Well, you don't respect the judiciary. If you had respect, listen, I don't know how many judges offer that. I'd be surprised if there's more than 3 in the state that do that. Maybe they are, maybe they all do it. I don't know. But when I tell you that you have to at least give us the courtesy of calling up and going on Zoom and requesting an extension, and you don't do it, and you blow it off for 3 months, it doesn't make me happy.
Understand?
Do you?
Yes, sir.
Where you were?
For
Ford Motor?
the tech center
Where?
on 401 Greenfield.
You didn't take off 2.5 months working at Ford. They'd have fired you
No, I just started Monday,
Monday.
this past Monday.
Yesterday?
Yes, sir.
You started yesterday.
Yes, through a temp service.
I don't believe you. Okay? I don't believe you were in Atlanta for 2.5 months.
They were helping my father.
Just so you know, I don't believe you. Okay? I have people lie to me every day. All right?
Mhm.
I don't know what it is. Maybe I don't look very smart. But I get tired of it.
I understand.
Do you?
Yes, sir.
This is a courtroom. We're not in a bar. We're not telling fish stories. You pull this nonsense with me again, you're going to force me to put you in jail on a civil infraction, and I won't hesitate. Do we understand one another?
Yes, sir.
When can you start paying this?
I have the full pay next month. That's correct.
Are you sure?
Yes, sir.
I can give you more time if you want.
No, that's fine.
What are you going to do if you don't have the money?
I'll have the money. Okay.
No. Let's say something happens. Your engine goes out on your car. The bank forecloses. You got a credit card. What are you going to do if you don't have the money?
Reach out to family and friends.
No, you're going to call the court, or you're going to drive to the court on or before the due date at 8:30 in the morning. I'll give you an extension.
Okay.
I mean, I can't be more fair than that, can I?
Correct.
You pay by May. Week from Friday is the 8th. I'm giving you till the 13th. Again, I don't want to treat you like a child. What are you going to do if you don't have them? On or before the due date, right?
Right.
That's if you can operate Zoom. If you can't, you have to come in here on or before the due date, okay? All right, May 13th. Good luck.
Thank you.
Timothy Jamie Whittle. 25B148379B. 21F235726A. 25B148379C. And 25B148379A. Your name.
Timothy General.
All right, so Mr. Whittle, I set a sentence date. This was first of all, let's talk about the possession of a controlled substance. But I want you to understand before we go further that you have the right to an attorney. If you, either way, I will be glad to appoint you on a public expense. Do you understand?
Yes.
Would you like an attorney?
No.
Are you sure?
Yes.
You had one before, didn't you?
Yes.
I think you need one. Now, here's the problem. Our probation court-appointed lawyer got detained in Florida, I believe. His flight didn't go out, so we had to call somebody. So I'm going to give you your choice. You can either wait for him to get here, and I don't have any idea how long it will take. Or I'll reschedule this for a week or two. And that'll give you more time to come up with money and do whatever else. So I'm gonna give you your choice. What would you like to do?
Reschedule.
I'd get going on this if I was you. Heather, when
Yes,
are we
sir.
gonna, when are we gonna reschedule this probation? I can go a week, I can go 2 weeks, whatever you want.
We have probation docket next on May 11th.
Okay? So we'll make,
We should do probably 11:15.
at 11:15 in the morning, May 11th, 11:15 in the morning. Okay?
Yes.
I don't think you're taking care of this very well. I don't want to talk about it. I expect you, sir, to take care of your business. Did you hear what I said? Maybe you did. But something said defendant behind on payment plan, reschedule with probation violation hearing. That's what they said on April 14th. So unless you came in and paid and the staff made a mistake by not putting it on there,
I don't know.
I don't want you to talk until we get a lawyer for you, okay? So you're going to have to figure things out. How old are you again?
24. Time 25, Saturday.
Well, happy birthday. (5/11) at 11:15, they'll give you your notice down the hall, okay?
Thank
It's time to grow up. Okay? Time to grow up. Good luck.
you.
You too. Go down the hall and get your notice. What do you guys have in here? What's your name?
Michael Dubuque. Mine's Steven Chartrain.
Do you have them on the docket? What do you have, Mr.
Dubuque, ski ticket.
Did you meet with the department rep?
No, I'm supposed to.
Let me see that. What's he?
Spell it.
DEPUGH.
Yeah, at 9:30.
Oh, it's at 9:30. Is it a department rep?
Yes.
Sure. How about you?
I have the same thing. It's for a speeding ticket at 9:30, through Woodhaven.
I see it.
Have John take them over there when he gets back. Yeah, I understand. So you should be in conference room 3. Sadie, would you take them to that conference room and tell the department rep that they're here? Ma'am, what is your name?
Yeah.
There's a million Amandas. What's your last name? Okay, what are you here for?
Talk to the officer and just you here.
Okay, let's go get them set up. You're gonna go talk, you have a speeding or a civil infraction, right? Okay, go, she'll take you. Thank you. Stay seated, everybody.
Okie dokie, as Judge McNally jumps off the bench, a little preview of what will happen for you tomorrow if you are so inclined as to help us reach our Super Chat goal today. I just wrote this little Dr. Seussism for Judge McNally. If your pockets are empty and your payment won't come, don't hide in the shadows and act like you're dumb. Just pick up the phone or step into court, say, Your Honor, I'm short, and I'll give you support. Alrighty, my friends, let's go back to Judge Simpson. Perhaps if Judge McNally delivered it that way, it would actually sink through for people. Just saying.
That way, they'll know that it's dismissed. Come on. Thank you, Judge.
All right, thank you, sir.
Okay, that's 3. Yay. Alan's here. Gonna get better. Or it could turn and go south. Good, good. Yeah. I don't think. We're gonna read it.
Well, I wanted to give Judge Simpson a chance, but it seems like everything is fits and starts with him this morning. Good morning, Ellie. Let's go to Judge Maureen McGinnis. Let's see what's up with her.
Versus Mason Alpa.
Good morning, Your Honor. For the record, Eric Jess, trying to have Mr. Alpa, who's standing to my right.
Could you state your name, please?
Mason Stephen Opal.
All right, and Mr. Getz, you are recently retained.
As of yesterday, yes, Your Honor.
All right, and you'll be able to file an appearance today.
I emailed one last night, so it should be
Okay,
somewhere.
somewhere in the building.
But if not, I'll send out the one over.
All right, great. It looks like the parties have had an opportunity to pre-try the matter. There may be a resolution. If there's going to be an offer, could you place it on the record?
Yes, Your Honor. We have a count allowing unlicensed driver to drive and impeding traffic. If the defendant is guilty and responsible for those charges, and the court accepts, then we will dismiss the two original charges.
And that's how your client would like to proceed today.
It is your understanding, or it is, and it is our understanding of the offer also.
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Swear.
All right, thank you. You can put your hand down. Did you hear and understand the plea offer that's just been outlined in the record?
Yes, ma'am.
And did you have a full and fair opportunity to discuss your case with your attorney?
Yes, ma'am.
Did the two of you review this document we call People's Exhibit Number 1?
Yes, ma'am.
Did you answer all of the questions on the form truthfully?
Yes.
Am I looking at your signature towards the bottom of the second page?
Yes, ma'am.
Do you understand that the maximum penalty for the misdemeanor offense that you intend to be guilty to could be up to 93 days in jail, 2 years of reporting probation, and or a fine of up to $500?
Yes, ma'am.
You also understand for the civil infraction of impeding traffic, no potential jail or probation penalty could exist. However, you will be assessed a $200 fine, 0 points against your driving record.
Yes, ma'am.
Do you understand that if you're on probation or parole to another border jurisdiction, a guilty plea in this case could negatively impact your status somewhere else?
Yes.
Do you understand that as you appear before the court today, you have the constitutional right to contest the original misdemeanor charge that has been brought against you?
Yes.
Do you understand each one of the rights that you would get to exercise if you decided to go to trial?
Yes.
Do you understand that if I accept your plea today, you will be giving up your right to go to trial and will not have a trial of any kind?
Yes, ma'am.
Has anyone promised you anything or threatened you in any way in order to get you to plead guilty against your will? Say that again.
No, ma'am.
Is it your own choice to do this?
Yes.
Do you understand that if I accept your plea today, if you change your mind at a later date and would like to try to appeal your plea, the only way you can do that is if you're granted leave to appeal from the Oakland County Circuit Court?
Yes, ma'am.
Knowing all of this, is it still, oh, I'm sorry, there's one other. Do you also understand that if the court accepts your plea today, you could be giving up certain rights or issues on an appeal that you would have otherwise had if you had gone to trial?
Yes, ma'am.
Knowing all of these things, is it still your decision to proceed with a plea?
Yes, ma'am.
So I need to take your attention back to the date of the alleged offense, January 23rd, 2026. On that day, we in the city of Troy, Michigan.
Yes.
Were you in the area of South on I-75 at or near East Maple Road in the city of Troy?
Yes.
The allegation is that you allowed an unlicensed person to operate your motor vehicle on that day. How do you plead?
Guilty.
The allegation for the civil infraction is that you're impeding traffic in the same area in the city of Troy. Do you plead responsible or not responsible?
Responsible.
All right. Are the attorneys satisfied with the taking of the plea?
Yes, Your Honor. Defense is satisfied.
I'm satisfied as well. I will accept your guilty and responsible plea to these added allegations. In exchange for those pleas, I'll grant the motion that people have made to dismiss the original charges, which would have carried potentially higher penalties for you and additional points against your driver's license. So your client currently has a restricted driver's license. Tell me a little bit about what's going on.
This happened about a week before his hearing at the Secretary of State. He saw hearing officer Harmon Higgins. He told me that he explained to Harmon Higgins that a about this pending matter, and he still granted him a restricted license. So he showed me a picture of his license that was issued on March 5th. So he has a valid license right now, and by resolution in this manner, he won't have any license issued with the Secretary of State that he's grateful for. He's going to be in the interlock device. You've interlocked your car right now?
Yes, sir.
He's going to interlock device in his car, I guess, for maybe a year, depending on how much time he had before he lost the interlock. So
Okay.
I don't know. He's been, his sobriety date is November 1st, 2018. He hasn't had any real issues since that day. He does have some criminal history before that, but after November 18th, he's just had just some minor issues. So.
All right. Mr. Mossy, do you have an objection to immediate sentencing?
No, no,
Any position you're taking?
no objection to fines and costs, sir.
Is there anything you'd like to say on your own behalf, sir, before I sentence you? You got lucky. I'm really glad to see that you were able to complete the process, go through the hearing, and still be granted an opportunity to have a restricted driver's license. This plea offer will definitely allow you to continue on the path that you're on, but I know you recognize all of the work that's gone into getting the license back. So hopefully you will follow any and all restrictions that are coming along with the ability to drive very carefully. And I'm going to just simply impose fines and costs today. The fact that you were able to continue on the path that you had started before this happened is good. Could have definitely jeopardized that. So don't do anything that could potentially jeopardize all of the work that you've put into getting a restricted license. I will impose a set fine for the misdemeanor of $265. That's much lower than if I were to impose a $500 fine, $300 in court costs, and $125 for state fees. So your total for the misdemeanor is $265. Plus you'll have to pay the $200 civil infraction. I don't believe that you posted a bond. I'm going to give you 60 days to pay these in full. Will you be able to do that?
Yes, ma'am.
All right, please go to the front counter. They'll call you shortly to go over everything with you.
Thank you very much, Honor.
Thank you.
Have a great day.
Thank you too.
Grandma TCF, thank you for the $5. And Lindsay, good morning to you, and thank you for the $4.99. Very much appreciate all of that. Let's go to Judge Oakley.
Yes. Yes.
AP Lucky, are you going to make an appearance on this one, or?
I can, I need to, but Jacob Lucky appearing on behalf of the people, P88400.
Addie Satchwell, P85689, on behalf of Mr. Cox. Mr. Cox, can you please state your name for the record?
Yes, Joseph Cox.
Thank you. What do we got?
Your Honor, we are requesting an exam in this, and if that could be on the 12th, I would appreciate it. I have a funeral service next week, so I'm not available.
We'll check it out.
The 12th, we are
Okay.
at 10:15.
10:15 on the 12th?
That sounds good, and I'm just verifying that I've got.
Hold on. Heather's
Wrong. It's 11:30.
11:30.
Okay.
All right, bond will be continued. Where's that
Yes.
at?
Thank you.
That's live, my courtroom. All right,
Thank
we'll
you,
see you
Your
then. Mr.
And
Cox, we'll see you in a couple weeks.
All right, thank you. Have a good
And
day,
it-
Honor.
AP Lucky, I have paper but not digital, so if you could send that over. Thank you so much. Have a good day.
You as well.
Thank you.
Confusing with all these.
She's got like the world's best complexion. Oh. Notes. Notes is? He was next door. I can't remember where it was at, but he was here the week after. Somebody said his eye was pretty swollen.
Everything is so spotty this morning with these judges. It's all fits and starts. It's let's get rolling, and then they like walk away or things go silent. It's kind of crazy. Hopefully that improves. Let's go back to Judge McGinnis, new contestant there.
All right, can you state your name for the record?
Mark Elias.
Are you still using a mailing address on Hickory Woods Drive in Clinton Township, apartment number 6?
Yep.
So I'm just trying to get a sense of what's happening here. Today is a date and time that has been set for a pretrial. That he was ever actually arraigned on the bench warrant that was in place. Did you appear for any sort of arraignment, or did you file an appeal?
The arraignment was waived. When we came for the arraignment, we came to the counter and then they told us the arraignment was waived.
Because you filed an appearance?
Yeah, sure.
Okay, so we can discuss how we'll proceed if the court needs to consider any bond conditions at this point. It does look like the bench warrant was set aside, but I don't have any information that would indicate to me that potential bond was addressed for the case while it's pending. We'll proceed with the pretrial today, and it does look like the parties have had a discussion and may have pre-tried the matter. If the people are making an offer to Mr. Elias, could you please place it on the record?
Yes, we looked at a kind of allowing a licensed driver to drive. We're going to plead that charge and court accepts. We will dismiss the original charge.
All right, is that how your client would like to proceed today?
Yes, Your Honor.
All right, please raise your right hand, sir. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
All thing like that. All that.
I'm sorry, I couldn't understand that.
Like I do everything right thing.
So that is a yes.
Tell the truth.
Yeah, I will do everything into it.
Okay, thank you. Sir, did you hear and understand the plea offer that has been stated on the record by the people?
Yes, sir.
So I just want to ask one quick question, because for some reason at some point this case was designated as a case that required an interpreter. Do we think that that's necessary? I don't know why.
No, it's not necessary.
Okay, I just want to make sure, because we had made that decision at some point. It does look like it was removed for today's date, but I just want to make sure that that's correct.
That's correct, Your Honor.
Okay, sir, did you discuss your case with your attorney?
Yes.
And did the two of you review this document here?
Yes.
Did you go through this document with your attorney and answer the questions truthfully?
Yes.
After you reviewed this document with your attorney, did you sign toward the bottom of the second page?
Yes.
Now, do you understand that the maximum penalty that could be imposed by the court for this offense that you're going to plead guilty to, it could be up to 93 days in jail, 2 years of probation, and or a fine of up to $500?
$500.
So you understand that all of those things could potentially be part of a sentence?
Yes.
And do you understand that if you are on probation or parole to another court or jurisdiction, a guilty plea that you give to the court in this case, it could negatively impact your status somewhere else?
Yes.
Do you understand that as you appear before the court today, you have the constitutional right to challenge the original charge at a jury trial?
Yes.
Did you go through with your attorney each one of the rights that you would be able to exercise if you went to a trial?
Yes.
And do you understand that if I accept your plea today, you will be giving up your right to go to trial?
Yes.
Has anyone promised you anything or threatened you in any way to plead guilty? Could you speak up?
Yes, I'm guilty.
Okay, so we have to record your answer, so I can see that you're shaking your head like this, but I need to have a very clear yes or no.
Yes.
So let me just ask you this question one more time. Has anyone promised you anything or threatened you in any way in order to get you to plead guilty against your will?
Yes.
Someone promised you or threatened you?
No, nobody.
Okay, and is it your own choice to plead guilty today?
Yes.
Do you understand that if I accept your plea today, if you change your mind later on and want to try to appeal your plea, take it back, the only way you can do that is if you're given permission to do that from the higher court? Do you also understand that upon entering a guilty plea today, you could give up certain rights or issues on an appeal that you would have automatically had if you had gone to trial? Yes?
Yes.
Knowing all of this, is it still your decision to proceed with a guilty plea? So I need to take your attention back to the date of the offense. So this would have been May 7th of 2025. Do you remember that day?
Yes.
So the ticket alleges that you were in the city of Troy, Michigan, in the area of West Big Beaver Road at or near the Huntington Bank.
Yes.
You remember that?
Yes.
The ticket alleges that you allowed an unlicensed person to operate your motor vehicle. Do you plead guilty or not guilty?
No, I'm guilty.
Are the attorneys satisfied with the taking of the plea?
Satisfied.
Satisfied, Your Honor.
I am satisfied as well. I will accept your guilty plea. In exchange for your plea, I will grant the people's motion to dismiss the original charge, which would have carried higher penalties for you. It also likely would have suspended your license. I can see your client has a valid driver's license now. What would you like to say on his behalf?
Yes, Your Honor. I mean, the defendant, he accepts full responsibility. This was a poor judgment on his behalf at the time, and it's been over a year. He hasn't had any tickets since then. He apologized to the court as well as to the officers in the case. He's 32 years old. He supports himself. This was a mistake, and she promised that he will never, he'll be more cautious when he's driving. Luckily in this case, there was no accident, no injury, no alcohol-related matter. Your Honor, we asked for minimal, non-jail sentence consistent with this type of case.
Okay.
Thank you, Your Honor.
Anything from the people?
No objection to just fines and caution.
And sir, would you like to say anything on your own behalf before I sentence you?
No, thank you so much. I appreciate that.
Okay, I am going to impose fines and cost only, no jail or probation, because of the fact that you've obtained a driver's license at this point. You've been up before the court on a couple of occasions, and I think you might have forfeited a few bonds as well because you didn't appear. So it's been an expensive endeavor for you. But at this point, I would like to recognize the fact that you have the license. Your driving record is not great, so you really have to be driving with the utmost care and caution and pay attention to all of the rules of the road to avoid additional tickets. But for today's purpose, I will impose a fine and court cost consistent with our set fine of $265. So that will be the total. I do believe you posted a bond in January that may be able to be applied to this. So we'll ask that they do that if they're able to, and then you'll pay the difference within 30 days. It should be a very small difference if they can apply the bond. Do you have any questions? All right, that's it for today. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
So reminder for tonight, friends, sidebar, 8 p.m. Eastern, 5 p.m. Pacific. With Dan and the crew and the TCF gang, we'll chat through the cases and see what they bring. No scripts, no AI, just real folks like you. So hop on the sidebar. We'll see you there too. Speaking of Dr. Seussing, Lindsay, $5 times 2. Thank you. Ashley, thank you for the $5. And Todd, thank you for 5. And Lindsay, thank you for $4.99 more. So what does that put us at? We're at 9 out of 10, almost there already, and we haven't even cracked the first hour. Thanks, guys. I really appreciate it. And this is one of those fun, stupid Dan tricks that I do, so it's cool. Let's go back to Judge Oakley and see if he can last more than 30 seconds this time.
Yeah. All right, counsel, your appearance or actually both of you, appearances for Britney Stevens.
Good morning, Your Honor. Jacob Leckie appearing on behalf of the people, P88400.
Good morning, Ron. Thank you on behalf of the defendant. 361-917, Stevens, please tell the judge.
Okay, Steven.
Good morning. Need a jury trial date?
I'll take your honor.
All right, we're looking.
Just a couple matters of housekeeping. I've already spoken to the prosecutor about this. There are 4 body cam videos that I'm assuming may or may not be evidence. Those body cam videos do contain some discussion of things that are inadmissible.
Okay.
Prior bad acts and some of those things.
Right.
I've discussed it with the prosecutor. I'm going to try to get some sort of resolution in regards to trying to redact those portions.
Okay.
Or I suppose the prosecutor could file a motion for prior bad acts, but either way, we're going to be working.
Okay.
Just bring it back to the board.
That's fine.
28 or June 29.
June, is that June, Heather? I'm sorry.
May 28th, June 29th.
Already zapped on May 28th.
Okay.
I have it.
Right. Both those dates I'm in trial.
Well, you better be in trial with us on May 28th because it's your case.
Mm-mm. I can't.
With Mr. Mays and you and Miss Johnson. That's Mohammed.
Hold on.
May's doing the domestic. That's on the info.
It's yours, Mr. Leckie. May 28th.
May 28th. Okay, I'll have to get someone to cover it. I don't know why I don't have it. Okay.
So.
Which case is that? Is that Wilma?
I have Thursday, July 2nd.
Yeah.
It's Thursday, July 2nd, gentlemen.
July 2nd. Works.
I was waiting for Joe to invite me out to the lake, but.
You make that work, Judge?
Okay, bond will be continued. That gives you plenty of time to work out your video issues. All right, man, just have a seat. We'll get you paper notice.
Sorry, any additional?
And then
Jury trials on this court. Perfect.
I'll send you a scheduling order a couple weeks ahead of time. That'll explain everything.
Awesome, appreciate it.
Yeah.
Thank you.
You're welcome.
Okay, friends, we made the goal. Thank you so much. Lindsay, thank you for 5 more. Nina, thank you for 5. Mike, thank you for 3. And Ashley, thank you for another 5. So I'm going to get busy this afternoon and do some writing. I will obviously write the opening ahead of time, but what I'm going to try to do for tomorrow is I'm going to try to write the closing in real time and make it relevant to what we saw during the show. So that will be what we will do tomorrow. And I appreciate it. Thank you, guys. Thank you so much. All right, since once again, Judge Oakley has walked away. Everybody's like walking away this morning, you know, or pausing or taking breaks, or I don't know. It's weird today. Let's go back to Judge McNally, though. He just came back.
Good morning, sir. Your name?
James Lambert.
All right. You are going to plead responsible to impeding traffic, and they are going to dismiss the original charge of speeding, correct?
Correct.
To that charge of impeding traffic, responsible or not responsible?
Responsible.
I'll accept your plea, dismiss the speeding, 150 is your total. You can go right down to the cashier.
Thank you.
Have a good day. Thank you. All right, Cathy Mohammed Salah, 260-647-7753. Good morning, ma'am. Your name? All right, so you went into default. You filed a motion to set aside the default judgment. You posted a bond. They met with you and you were going to plead responsible to impeding traffic, correct? To that charge, responsible or not responsible?
Responsible.
All right, you got a couple, 3 on here, so 180 is your total. You have a bond of 165. Go down the hall, apply the bond, pay the other $15, and you're all set. Okay? Good luck. Default judgment set aside on that, Heather. Default judgment set aside.
Austin, 8 months of being a TCF member. Thank you so much for all the support you've given. And you can see Austin tonight on Sidebar, which we just talked about, 8 p.m. Eastern, 5 p.m. Pacific, right here on this channel. So join us there.
To impeding traffic, correct? To that charge, responsible or not responsible?
Responsible.
I'll accept your plea. It's a first offense. 150 is your total. You're all set. Go down the hall and take care of that.
Thank you.
Best of luck. People against Baumia, Richard James Baumia, 26B150491. Your name? You're going to plead to impeding, right?
Correct.
To that, and the failure to yield causing an accident will be dismissed, correct?
Correct.
To that charge of impeding traffic, responsible or not responsible?
Responsible.
All right, so it says no injuries, vehicles drivable, 195 is your total. Be careful though, okay? Good luck. The original charge is dismissed. People against Maxwell, Jacob Anthony Maxwell, 26B150524A and B. Good morning, your name? All right, so you're going to plead to impeding traffic. The careless will be dismissed. You're also going to plead to the equipment violation, true? All right, to that charge of impeding traffic on file A, responsible or not responsible? And to the equipment violation on file B, responsible or not responsible? Gotta be careful. You understand what I'm saying? Got you going, squealing tires. You went into the oncoming traffic lane according to the report. All right, I'll accept, so again, I'll accept the plea to impeding, 225 on that one, and I'm going to accept the plea to equipment violation. And that one, I'll charge you $135. You can go down the hall and pay those $260. You're all set. Good luck. I mean, $360, I'm sorry. People against Collins. Devin Tyler Collins, 25B149773A. Good morning, your name? All right, Mr. Collins, you are on probation. And I have a charge here that alleges that you violated probation. I placed you on probation on the charge of operating while impaired. January 29 of 26. This charge, which would be your first technical violation, alleges that you did fail to refrain from consuming alcohol or drugs testing positive for cocaine on an April 1, 26 chemical test. Do you understand the charge?
Yes, sir.
If you plead guilty or if you're found guilty, you could get 5 days in jail. Do you understand that?
Yes, sir.
And did you sign, read, and understand the advice of rights form here today?
Yes, sir.
If you plead guilty, you'll be giving up both of those rights, and we are not going to have a hearing of any kind. Do you understand that? All right, you do have the right to an attorney if you cannot afford one. Either way, I'll be glad to appoint you one at public expense. Do you understand that?
Yes, sir.
Would you like an attorney?
Yes, sir.
I'm going to enter a not guilty plea. I will give you a lawyer. We'll set you up with the probation lawyer that just arrived, and we'll go from there. You also have a B file, by the way, where you pled the possession of a controlled substance. And the same thing exists on that. That would be a first violation. And that probation you could receive 5 days if you plead guilty or are found guilty of this offense. And since it was taken under section 7411, which I explained to you previously, that 7411 status could be revoked, the conviction entered, and you would be subject, like I said, to new sentencing and up to a 5-day jail term. Do you understand that?
Yes, sir.
All right. Any questions before I give you your lawyer? All right, go out in the hallway. We'll set you up with an attorney, and he will speak to you, and then you'll both come in together. Okay?
Thank you.
Morning, Ms. Westmoreland.
Hey, good morning, Judge. How are you?
Good, thanks. How about yourself?
Good, good, thanks.
Tishkoff. Jenna Jolene Elizabeth Tishkoff, 26F245-94950. Good morning, ma'am. Your name? All right, so that was the probation term. You are charged with driving without due care and caution. There was an accident. Both vehicles were drivable. You have the right to meet with the department rep. You did do that. He's indicating both vehicles were drivable and there were no injuries. This says you are going to plead responsible for impeding traffic. Is that how you wish to proceed?
Yes, sir.
To that charge of impeding traffic, responsible or not responsible?
Responsible.
Original charge is dismissed, 195. Cashier end of the hall to your right, okay?
Thank you.
Be careful, please. Suzette Kennedy West, 26F246992.
Judge, I believe that she came up to the window and just paid that. We were told there was no deal on that, and she came up to the window and was gonna pay it.
Okay, I'll just make a note. Defendant accepted responsibility, paid the ticket. That was a charge of impeding traffic. Witts, Chad Austin Witts, 260-150-245. All right, good morning. Your name?
check with.
You are going to plead to prohibited parking, true?
Yeah.
To that charge, responsible or not responsible? Plea is accepted, $85. You are all set.
Thank you.
Have a good day. Original charge is dismissed. People against Stephen Chartrand. 26W41988. Your name?
Stephen Charter.
All right, you are going to plead responsible to impeding traffic. They're going to dismiss the 75 and 70. They got you at 85 and 70, correct?
Yes.
To that charge of impeding traffic, responsible or not responsible?
Responsible.
Plea is accepted. 155 is your total. Cathy, you're under the lights. You're right.
Thank you.
Good luck. I'm dismissing the limited access charge. Jonathan Samuels, 26W841995. All right, your name?
Jonathan Samuels.
All right, they're dismissing us. You gotta have your plate up to date, though. You follow me? I mean, a lot of them wouldn't do this. I'll go along with it. It's an expired plate and it says it was 2 weeks old and you renewed it, so I'll go ahead and dismiss that on their motion. You're all set. Good luck. Alicia Hartner, 26W841996. Your name, ma'am?
Whoever's phone it is,
You gotta take it out of here. Get it out of the building, please.
Sir, you gotta take your hat off to you in the courtroom.
Ma'am, you gotta be careful.
Yes.
I'm not sure I should take this. You got one out of Romulus that was an impeding traffic. I generally go back 7 years.
We'll see that I have not received any violations and.
I know, but your record looks bad. You realize that, right? You got 1 in 20, a speed. You got another one in, hang on, let me finish. You got another one in 21 impeding that they probably wrote you for something else with, or you pled to impeding. Then you've got a speeding in 21. You got a speeding in 22, and now you've got this one.
I drive for a living since, so I've kind of maintained that since.
Ma'am, I'm not sure you qualify for this. I'm gonna do it for you because I'm not gonna make assumptions on what happened on the other one, but you're gonna pay $195 to the charge, impeding traffic, responsible or not responsible.
Responsible. I would ask that I be able to pay $100 today and in 2 weeks the remainder.
$100 due now, the total's $195, and you come back on May 11th. If you see my name on the ticket next time you get one here, you live in Woodhaven, you might want to consider I'm not taking impeding, okay? You gotta slow down, all right?
Good day.
You too. Kenneth Talton Jr., 26T647651. Kenneth Talton.
Yes, Your Honor.
They didn't offer your name? They didn't offer you impeding traffic or what?
They did.
You don't want to do that?
I wasn't speeding.
They got you going 38 and a 25. It's okay. I mean, I'm not trying to talk you into it. If you don't think you were hang on, let me just finish here.
Yes, sir.
I don't have a problem. If you don't think you were speeding, you shouldn't plead to anything. I'm only telling you, if you go to a hearing and you lose, you're going to get a point added to your traffic record. You've got a clean record now.
That's it.
Well, you got a 38 and a 25. I'm just telling you. If you think you were going 25 on Grange, that's fine.
Yeah, my only problem is he was before West. I was after. I feel like it's obstruction.
If you think you weren't speeding, Grange is hard to go 25 on. I'm not gonna lie to you. It's hard to go 25 on Grange. If you want a hearing, I'm not trying to talk you out of it. I want to be clear about that.
I'm coming before you.
You're coming before me.
You sound like you convinced that I'm guilty of.
I'm just saying they got you on radar going 38 and a 25. I'm not convinced of anything. I'm just trying to caution you. You want to go to a hearing and you lose, you're going to have a point. I'm not convinced of anything. You want to have a hearing? I'll be glad to give you a hearing. I'm not trying to talk you out of it. I just don't want you to be blindsided here, because if you lose, you got a conviction on your record with a point. You want to set it for informal because you don't think you were speeding? No problem. I have no issue with that.
What's the fine?
I'm not going to negotiate with you. I'm reasonable.
No, last.
I'm not going to negotiate with you. Okay? I know you're asking. This is a $135 ticket on a first offense with a clean record. In fact, I don't generally charge. I would charge $150. So that's as close as I'm going to come to talking to you about it otherwise. But if you want a hearing, please, sir, I'm not trying to talk you out of it. They're not always right. That's fine. You want to think about it?
I'll pay the fine.
No, I want to make sure that's what you want to do. Why don't you sit down and take a minute to think about it, okay? And then I'll call you. I will not keep you there. You go.
If I'm coming back before you, I'd rather pay.
Well, listen, don't make it sound like I'm not fair, because I'm fair. All right, so you don't have to. I'm just telling you somebody signed a ticket, an officer under oath, saying that we're going 38 and a 25. That's all. And you don't have to be going 30. If I'm convinced you're going 26 and a 25, you're going to be convicted of it.
Saying I already felt that. So I just paid the fine. Pay the fine, sir. I felt like.
Listen, don't play this psychology. Let me stop. I'm going to be fair. That's what I do. But I don't make, oh, you're already, no. I'm not convinced of anything. I'm just telling you, I got a police officer here. I got a clean record. I got a signed a ticket under oath saying that you were going 38 and a 25. He might be crazy. Maybe you're going 3 and a 25. I don't know. I don't want to deter you. And I don't want to hear this stuff. I'm coming in front of you. You're already convinced. Please don't play that psychological garbage with me. I don't want to hear it. I'm just trying to be fair with you so you understand the consequences. If you want to go with a hearing, I'm going to be fair-minded. I'm going to listen to what he has to say. I'm going to listen to what you have to say, and I'm going to make a determination. I just want you to understand that if you lose, you don't get impeding. That's what I'm trying to tell you. That's what they call plea bargaining.
That's right.
Sit down and have a seat for a minute and think about it. Sit down. No, you want to go with the hearing?
Want to go with impede?
No, I don't. You haven't thought about it enough. Sit down and think about it. Sit down and think about it. I don't want you to walk out of here, or anybody else to walk out of this building and say the guy wasn't fair with me. That's not what I'm about. I'm trying to be fair with you. That's why I told you what was up.
Yes, sir.
Have a seat. I'll be right back with you. I promise you. I'm not going to punish you by keeping you here. Joshua Aaron Frost, 260-647-510. Your name, sir?
Sure, Fox.
Okay, the child has to go out of the courtroom, please.
Yeah.
I love children, but I can't have them in here yelling and screaming. Your name? You're going to plead to impeding, right?
Yes.
Responsible or not responsible? Disobey traffic signals dismissed. 150 is the total. Cash your into the hall. You're all set. Good luck. Amanda Marie Frazier, 26T647975. Your name?
Amanda Frazier?
Good morning. You're going to plead to impeding, correct? You've got a clean record to that charge, responsible or not responsible.
Responsible.
Plea is accepted. Amber Light charge is dismissed. 150 is your total. You're all set. Go down to the cashier, make your payment. Best of luck to you.
Thank you.
People against Michael Andrew Depew, 216-648-063. Good morning. Your name? You're going to plead to impeding traffic, right? To that charge, responsible or not responsible? All right, please accepted. 155, cashier end of the hall to your right. You're all set. Have a good day. And good luck to you. People against Hussein M. Boomrod, 26B150748. Good morning. Your name? You're going to plead to impeding traffic, correct?
Correct.
To that charge, responsible or not responsible? All right, you got to be careful, okay? 170 is your total. You got a couple entries on here. Be careful, all right? Cashier into the hall to your right and you're all set. Thank you. People against, can you put that back in here? People against Shrivastava. Aman Shrivastava, 268842-165, A and B.
Oh, Judge, he's on Zoom. Somehow he got back into a breakout room. I'm trying to get him out.
Okay.
There he is.
Good morning, sir. Your name?
My name is Aman Shrivastava.
All right. So you want an informal hearing?
Yes, Your Honor. I wanted that, but I was trying to explain to the prosecutor before.
It's not the prosecutor. It's a department rep.
Yes, I was speaking with them. With him, and I was explaining that I had 160 slaughter hogs with me when I was traveling with the.
Slow down. You explaining to him what?
I had a live load of 160 slaughter hogs. I had livestock on board, and I had, like, everyone was braking in front of me very hard, so I had to go in the left lane to momentarily pass the traffic. I was not traveling in the left.
You didn't want to take what he offered you, right?
He offered me like out of 2 tickets, 1 ticket does not make sense because I had insurance.
Slow down. He offered you what?
He offered me impeding traffic ticket.
Okay, if you don't want to do that, that's fine. You got a commercial vehicle license, right?
Yes.
All right, well, he's got you in the left lane, it sounds like. And you can't do that. So if you want to set an informal hearing, no problem. Just know that if you lose that, the points are getting assessed on your record. It's up to you.
I just want to add one thing, and
I don't want to add anything. I just want to know, is that what you want to do, is set it for informal hearing?
I'll pay for the impeding traffic.
Listen, again, I don't care what you do. These hearings take 5 minutes, 7 minutes. If you want to have a hearing, I'm not trying to dissuade you from that. It's up to you. I just want you to be aware that if you are convicted, that it's going to go on your record. That's all.
I understand. I understand that. And the only reason I wanted
I don't need to know your reason. If you want an informal, I'll be happy to give you an informal, sir. I'm not trying to talk you out of it.
No, I understand that completely. Yeah, 100%.
Because somebody's kind of just accusing me in here of trying to talk them out of it, and that's the last thing I want to do. So do you want me to set it for informal?
Yeah. So no hearing. No hearing. I just want to pay for the charge I was offered for. That's all I want to do. Yeah. I'm not sure. I don't understand certain words, but I do understand. I don't want any hearing. I will go back to the administration representative who offered
I gotta send you back to the department rep, but I swear to you, I'm not trying to talk you out of going to a hearing. I want you to understand that.
Yes.
Okay.
Yes.
All right, that's what I'll do. I'll send it back to the department rep. That's got to go back to Woodhaven's. Kenneth Talton Jr., 26T 647-651.
Yes, Your Honor.
Your name?
Yes, Your Honor. Kenneth Thompson Jr.
What have you decided to do?
On second, please.
You sure?
Yes, sir.
Want to make sure, because I can promise you, if you are accepting impeding only because you think I'm not going to be fair with you, that's the last thing in the world that I want.
Yes, sir. I'm accepting.
You sure?
Yes.
You have to go back to the Trenton department, okay? Because he's written it up like you wanted to hear it. And that'll give you a couple more minutes. If you change your mind, no problem. I swear to you, I'm not trying to talk you out of it. John, this one has to get back to Trenton rep. Okay? Thank you. You go back and talk to him. Thank you. Thornton. Lamar Eugene Thornton. 4B 702-123FY. That has to go back to the Trenton rep.
Okay, do I need to tell them anything about it, or?
He wants impeding now. Your name? So, here's where we are with this one. I find you. I placed you on probation for 24 months back on April 28 of 25. You have one prior technical violation. The charge here is now that you failed to pay your fines and costs as ordered of $1,115. If you plead guilty or if you're found guilty, that would be a second technical violation, and you could receive 10 days. Do you understand that?
Yeah.
And did you sign, read, and understand the advice and rights form here today? Plead guilty, you'll be giving up all those rights. And we're not going to have a hearing of any kind. Do you understand that? All right. Give me 1 second here. All right. You have the right to a lawyer. I will be happy to provide you with one at public expense if you would like them. And you understand that if you plead guilty, you could get 10 days, right? You waive your right to a lawyer, is that true? To that charge then, that you failed to pay $1,115, your fines and costs as ordered, how do you wish to plead? Did you fail to pay your fines and costs as ordered?
Yeah.
Has anybody forced you to plead guilty?
No.
And you're sure you want to waive your right to a lawyer?
Well, yeah.
All right. Well, I'll accept your plea. I find it to be an accurate plea made voluntarily and understandingly. The plea is accepted. Why didn't you come and talk to me?
For the most part, I was handling all my previous warrants from my whole ticket, so I just started. So mine got card. I started taking care of each one at a time.
Remember when I told you you were supposed to pay 50 per week beginning on September the 12th?
Yeah, then
Hey, slow down.
Okay.
Do you remember when I told you that? Did you do that?
My probation officer, she told me to focus on the ticket that.
Call in his probation officer.
What's the name on this one?
This is
Ms. Wild.
Lamar Thornton and it's Ms. Wild. She didn't.
She had told me to pay off the Browns, basically that probation because there was children. So I was focused on paying that. And
Well, she gave you extra time and you paid nothing. Remember when I told you you needed to come talk to me if you didn't have the money?
Yeah.
You didn't do that, right?
Right.
This is now 6 months later, right? 7 months later?
I do want to note that I have each one of my courts that.
Sir, do you remember when I told you to come and talk to me if you didn't have the money? Why didn't you do that?
I'm brain with this on another level, and I was trying to take care of what she asked me about. I thought I would be okay with just taking care of the probation and getting started and take care of it.
You know, this is a 1-year misdemeanor, right? But I told you to come talk to me. Why didn't you come and talk to me?
I just, I wasn't thinking about it, so I just.
Weren't thinking about it. This is why else your
I
name.
was focused on too many courts at a time to where I actually didn't sit down to like, come and sit in here and advocate, to tell you that I was.
Your name?
Elizabeth West.
Did you tell him to take care of the other courts first?
He is scheduled to be off probation. He has a case with Judge Hessen. He missed his deferred judgment date. He had just paid that off in order for that case to be dismissed. So I did talk to him about making effort to pay to be able to get the warrants cleared that he had to get cleared as well. So.
Yeah, I know, but I told him to come and talk to me.
Yes.
And I don't want him talking to probation officers. I don't mind if there's a little leeway, but this one was 6 months. He hasn't paid anything on this. Where do you work?
Right now, I'm doing business.
What kind of business?
Mostly I get my income from paying, but right now I'm converting the trailer into a food trailer.
Has he been doing his, did he clear all the other warrants?
Yeah, he's got a couple left to go, Your Honor. We were in court back in September. Allotted him a little bit more time. Every time I do Lamar, I do run his record, and he's clearing them as we go. But it is the money that is surrounding Mr. Thornton in regards to his ability to just close those out.
All right. Now, I want you to listen to me clearly. I'm going to give you an extension. I'm going to assess additional costs of only $50, even though it should be a lot worse. You haven't paid and you didn't come and talk to me like I told you. So I'm going to let you be the judge now. You're going to tell me when you can pay, how much you can pay on whatever basis that there is, whether it's weekly, bi-weekly, monthly, I don't care. You understand? When can you start to pay on this? Tell you what, I'll just start having you pay $50 per week. And I won't even start it. I won't even start it until a week from Monday, which is May the 11th. Now, I don't have a problem with this. If you call the court and say, Judge, I don't have the money, you call the court at 8:30 on or before a due date, they'll set you up on Zoom. I'll be glad to give you 48 extensions if I need to. But you cannot ignore me like this. Do you understand that? I hope you do, because next time I'm not going to be this nice. When I offer people that, and then they don't come in here, I don't understand it. So I'm going to do this for you. No more. If you need more time, it's not an issue. How fair is that? Good luck. Lisa Kreider, 267-884-2063. Thank you.
Okay, friends, let's change it up a little bit. We haven't been here in a while, so let's go to Judge Mogan in Wisconsin. Looks like they've got some kind of motion hearing, and they're going to put a sheriff's deputy on the stand. So let's see what that's all about.
Record in the matters 20. Antonio Morales. The state appears through Assistant District Attorney Jose Vila in person. We have Daniel Chapman, Defense Counsel in person, along with Mr. Morales. We're set today for a motion hearing. Are you ready to proceed?
Yes, Your Honor.
All right, Mr. Vila.
Thank you. Thank you, Your Honor. State calls Deputy Jeff Carroll to the stand.
Deputy Carroll, can you please come forward? Raise your right hand. You're going to be sworn in, then come have a seat at the witness stand.
Do you swear that the testimony you're about to provide today in this matter is the truth, the whole truth, and nothing but the truth?
Yes.
All right, you may begin.
Can you please state and spell your name for the record?
My name is Jeff Carroll. Last name spelling Carroll.
And how are you currently employed?
I'm currently employed by the Burnett County Sheriff's Department.
Were you employed on that capacity on January 1st, 2026?
Yes, I was.
Did you receive any training prior to becoming a police officer?
Yes, I did.
What was that training?
The 720-hour law enforcement academy in Northwood Technical College.
And was any of that training focused on the detection of alcohol?
Yes.
On January 1st of 2026, did you respond to a call about a vehicle in a ditch?
Yes, I did.
Where did you respond to?
I responded to County Road Diaz and David near Cemetery Road in Wood River Township.
Is that area located in Burnett County?
Yes, it is.
After arriving on scene, did you make any observations?
I did.
What observations did you make?
I observed a vehicle in the ditch on the south side of County Road D. I observed it was like a gray colored kind of SUV type car. It appeared to be occupied by one male. I observed the vehicle was on and running, and the front driver's side tire was still spinning.
Did you make contact with the driver?
I did, yes.
Who was the driver?
The driver was identified by Wisconsin driver's license as Antonio Morales.
And do you see that same Antonio Morales here in the courtroom today?
I do, yes.
Could you please ID that Antonio Morales by where he's sitting and what he's wearing?
Yes. Antonio is seated next to defense counsel. It appears he's wearing a darker colored button-up top.
Let the record reflect that Deputy Carroll has identified Mr. Morales.
Did you notice anything about Mr. Morales after you made contact with him?
Yes. Immediately after making contact with Mr. Morales, I detected a strong odor of alcohol coming from inside the vehicle and his person. His eyes appeared to be half open and glassy and bloodshot, and his speech was kind of broken and a bit slurred.
Did you speak with Mr. Morales?
I did, yes.
What did you talk about?
Spoke about where he was coming from, where he was going, what happened.
What did he say happened?
He said he was going back to his house from a friend's in Luck when he went in the ditch.
Did you talk about anything else?
Yeah, I asked him how much he had to drink.
What did he say?
He said it was New Year's, so he had had a couple.
During the course of your interaction with Mr. Morales, did you conduct an investigation into possible operating while intoxicated?
Yes, I did.
What did you do as part of this investigation?
Part of the investigation involved standardized field sobriety testing as well as just other general questions.
And what field sobriety test did you perform?
The field sobriety tests that were performed were the horizontal gaze nystagmus test, the walk and turn test, and the one leg stand test.
And did you notice anything through these tests?
Through these tests, I observed enough clues, which led me to believe Mr. Morales was impaired. I observed 6 clues during HGN out of 6 possible clues. I observed 1 possible clue out of 8 during the walk and turn, and I observed 0 possible clues out of 4 during the one leg stand.
What did you do then?
I asked Mr. Morales if he felt he was safe to be driving, to which he replied, yes. I also asked Mr. Morales how intoxicated he felt he was on a scale of 1 to 10, with 1 being sober and 10 being the drunkest he ever been, which he replied 1.
What did you do after that?
I asked him if he would submit to a preliminary breath test, to which he replied no, because he said he passed the field sobriety test, so if it came out a little higher, he didn't want to do it.
What happened after that?
I advised him he'd be placed under arrest for OWI.
Okay. On January 1st, 2026, did you have a body camera on?
I did, yes.
Was it functional?
I believe it was, yes.
Prior to today's hearing, have you reviewed the video from your interaction with Mr. Morales on that day, January 1st, 2026?
Yes.
If I showed you that video, would you recognize it?
Yes.
Are you asking me to set up the equipment?
Yes, Your Honor.
Whatever she's setting up is dragging on a little longer than I expected, but we're a bit in the way back machine, so I'm going to try to push forward here a little.
Ew.
First off, you have video. Is this a fair and accurate description of what happened that day?
Yes.
If you could skip ahead to 30 seconds, please.
Seconds in a 3-hour video is kind of hard to be that precise, but there's
I'm gonna
36.
say I like the cooperation.
36, okay.
Yeah, that's fine. Thank you.
Hitting play.
Hit play. Thank you.
I guess I didn't realize that. Thanks for letting me know.
Yeah. What's your name, man?
I'm Antonio.
Okay. Don't worry. Do you have a driver's license, Antonio?
Yes, I do.
Alrighty. Whew. You're in there pretty good, my man.
Yes, I am.
You okay?
Yep, I'm like five miles away from home.
I gotcha. Where do you stay at, Antonio?
It's like between Webster and Siren.
Oh, okay. Like on County Road D or where at?
It's right off of County Road D.
Okay. Where are you coming from, Antonio?
I'm coming from all the way over in Luck, Wisconsin.
Really?
Yeah.
Why are you coming from all the way over there?
Well, that's where it's a long story. My house burnt down.
Oh man, I'm sorry about that.
I'd rather not explain the whole situation.
No, you don't have to. You don't have
But
to.
yeah, this is where I'm staying right now, and
okay, that's fine. Okay, how much you had to drink?
It's New Year's, so I've had a couple.
Couple, okay.
And
All right.
I'm being honest. I don't think I deserve a DUI.
Okay.
Because I'm literally on my way home.
Why don't you think you deserve a DUI? I guess you kind of jumped to that pretty quick. I didn't even say anything other than how much you had to drink.
The reason why is because
all right, man. You're good.
You know what I mean? Whatever. If you gotta do what you gotta do, do what you gotta do. It like
okay.
I don't think I deserve a DUI because but you got a job to do. So
yes, sir.
Whatever.
All right. Can I have you step out of the car, Antonio? My name's Jeff, by the way. I think I said that. I'll try to help you here. It's kind of steep. You need a hand or no? Okay, you got her. Alrighty, let's hop on the road here.
I was coming back from a friend's house, and
yeah, that's okay.
It's New Year's.
You can stand right there.
It's New Year's, man, and
yeah, I understand. A lot of people.
I was coming back from a friend's house.
I understand. A lot of people go out and do stuff on New Year's, man. There's nothing wrong with that. Okay. So you say if you to drink, do you think you'd be willing to do field sobriety tests?
Yes, Yep.
You would.
Yep.
Okay. Do you have any medical conditions or anything like that?
No, I don't.
No, you don't. Do you take any medications at all?
Nope.
No? Okay. Let me go turn off my red and blue lights.
That's okay.
I just don't want them to mess with your eyes, okay? 5-1 Summer, I'll be 10-6 fields.
10-4, is your subject the RO?
Don't worry, I'm 27 on it. Don't worry, any open cases. All right. Sorry, they're talking in my ear. It's hard to concentrate on a couple things at once, you know.
All good, man.
All right. Got a nice car.
Yep.
How long you had that bad boy?
A year.
Year. That's nice. Okay.
Before we start, do you got anything in your pockets at all? Any weapons on you? May I search you?
Check me all you
Okay.
want.
I just want to make sure you don't have any weapons. Or who's the buddy you were coming back from? If you don't mind me asking. I mean, it's not a big deal.
I mean, it wasn't too far, but it was like 10 minutes away.
Yeah, I was just asking what their name was, is all.
His name was Anthony.
Anthony? Cool.
Yep.
Is this THC vape? Looks like it.
It might be.
That's okay. Nothing in the back pockets at all?
All you want.
All right, man. You're good. I'm just gonna hold on to this for a minute. All right. So for the first test, I'm gonna check your eyes. Can I have you stand with your feet together?
Yep.
Heels and toes together, arms down at your side just like this, and don't move until I tell you to. Do you understand that?
Yep.
All right. So like I said, I'm gonna check your eyes. I'm gonna have you watch the tip of my left finger with your eyes and your eyes only. I do not want you to move your head. Do you understand that?
Mm-hmm.
Okay. Watch my finger, okay?
Just make sure you don't move it past the sight of where I can see, because otherwise I'm not going to be able to look that far.
Okay.
I've had it.
Yeah. Just follow it as best you can, okay? All right,
Yep.
we're gonna begin. Don't move your head. Don't move your head. You're good. You're doing good. You're doing good. Going. You're doing good. On.
As far then I can see.
Yep, I got you. Keep going. You see that or no?
If I move my head, I could see it.
Okay.
But
Here, I'll come back a little bit. Look at my finger.
That's the furthest I can see.
Okay.
Right there.
You're good. We're gonna do it one more time.
I'm not sure what's going on here. I think I might have tried to go into sleep mode.
Okay. Keep looking, keep looking, keep looking, keep looking. Good. All right. 2 more times in each eye here. Perfect. Perfect. Good. Last one. Good. Now we're gonna go straight up and down 1 time, 2 times, okay? Keep watching, keep watching, keep watching. Can't see that?
Yep,
Okay,
I can't
that's fine.
go that high.
All right, I won't go up high. This time.
Still can't. That's the highest I can.
That's
look.
good. All right.
That's the highest.
Perfect. You
Yep.
can relax. Thank you.
Okay.
Antonio, I'm gonna have you take your driver's. Can you put that in your pocket so I don't lose it?
No problem.
All right, Antonio, for this next one, it's called the walk and turn.
Yep.
I just want to make sure we're not gonna get schmucked here. All right, so for this one, I want you to place your left foot on an imaginary line out in front of you. So place your left foot on that line.
Okay.
Okay. And now put your right foot in front of your left foot with your right heel touching your left toe, just like I just did. All right. So now put your arms down at your sides and do not move from that position until I tell you to. Do you understand that?
Yep.
All righty. So when I say begin, you're going to take 9 heel to toe steps down this line, and then you're going to turn around, keeping your front foot on the line and taking several small steps with your other foot, returning 9 heel to toe steps on the line. So I'm going to demonstrate, okay? So I'm going to start in position just like you are. You're going to go look down 1, 2, 3, until you get to 9. And then with your front foot down, you're going to take a series of small steps to turn around. And then you're going to take 9 heel to toe steps back down the line. So 1, 2, 3, and so on until you're done.
Yeah.
Okay?
Okay.
All right. So for this test, it's important you remember to watch your feet at all times.
Yeah.
Keep your arms down at your side and count out loud, count your steps out loud, okay? Do you understand that?
Yep.
All right. You may begin.
1, 2, 3, 4, 5, 6, 7, 8, 9. That's my turnaround.
Okay.
1, 2, 3, 4, 5, 6.
Perfect. Thank you. Alrighty. Alrighty. So for this last one, it's called the one leg stand. Okay. So again, I'm gonna have you stand with your feet together, arms down at your sides.
All right.
Just like that. Perfect. So don't move from that position or start until I tell you to. Do you understand that?
Yep.
Okay. All right. So for this one, when I tell you to, you're gonna raise either foot of your choosing approximately 6 inches off the ground, just like this. You're gonna look down at your toe and you're gonna count out loud 1001, 1002, 1003, and so on until I tell you to stop.
Okay.
So again, the foot's gonna be off the ground approximately 6 inches.
Yeah.
Okay, you got that?
Yeah.
All right. So, yep, just keep counting out loud. So with this one, it's important you keep watching your foot. You keep your arms down at your sides and you count out loud 1001, 1002, 1003, and so on until I tell you to stop.
All right.
Do you understand that?
Yep.
All right, it's a pretty good one. So let me get ready here. I can find it. All right. Are you ready?
Yep.
You may begin.
1001, 1002, 1003, 1004, 1005, 1006, 1007, 1008, 1009, 1010, 1011, 1012, 1013, 1014, 1015, 1016, 1017, 1018, 1019, 1020, 1021.
You're good. Thank you. All right. So based on those tests and everything else today, do you think you're safe to be driving?
Yes, I do.
You do? Okay.
I literally, it's New Year's. I already had told you I had drinks before I went to bed.
Okay.
And I woke up and I had to get home. And
yeah,
these roads, I wasn't even hitting the brakes or anything. Like I did nothing wrong, officer.
Okay.
And
sounds good. Based on
if anything, I need some help to get out of the ditch.
Okay.
Yeah.
Gotcha. Based on a scale of 1 to 10, with 1 being sober, 10 being the drunkest you've ever been, where do you think you're at on that scale right now?
1.
1. You think you're sober?
Yep.
Okay. Understandable. And you think you're safe to be driving?
Yep.
Gotcha. You're not injured or nothing, are you?
Nope.
No. Would you be willing to do a breath test? PBT?
I'd rather not unless I have to. I feel like I passed the road sobriety test. So if it so happened to come up as a little over, I feel like
okay. You don't have to take it.
Yeah. I just rather not, man. Like,
so a preliminary breath test, they can't use it in court.
Yeah.
But you don't want to do it anyway, so that's fine.
Yeah.
It basically just helps me figure out like if I'm right in making the right decision.
Yeah, for sure.
But we're supposed to make an arrest decision before we have you do that.
Right.
Okay. Based on the testing and stuff I saw from you, I believe you're impaired. I don't believe you're super drunk by any means, but I believe you're still drunk. So you're gonna be under arrest for OWI.
Why do you believe I'm impaired?
Your speech, your smell, your eyes, and your driving behavior. You're in the ditch. And then with the tests I did with you.
What did I do wrong on the test?
Your eyes.
My eyes?
Yeah.
Well, that's nothing to do with the test, though.
It's part of the test.
Okay.
Yeah. That's it, man. That's it. So, all right, man.
That's at 13 minutes exactly. So purposes for the record, that video was played from 36 seconds until 13 minutes exactly. No further questions. We will be marking the video to move into evidence, but I imagine Attorney Chapman needs to use it first and foremost.
All right, thank you. Mr. Chapman, questions?
Deputy, how long have you worked for the Burnett County Sheriff's Office?
I've been employed by the Burnett County Sheriff's Department since 2020 as corrections and dispatch, and then in December of 2023, I went to patrol.
So you've been a patrol deputy for at this time, roughly 1 year? December of 2023 until, I guess, almost 2 years?
2 years, a little
Okay.
over 2 years.
How many times do you think you had done the field sobriety tests?
Including the academy and other training purposes.
Let's say in the field.
In the field, I would say a dozen, maybe more.
And you said you did the police academy training, and that police academy training involved detection of signs of impairment. Did you do any official training on the field sobriety tests?
Yes.
Were you trained under the National Highway and Transportation Safety Administration guidelines?
I personally can't recall the exact material they used in the academy.
You said that on the walk and turn test, you observed 1 out of 8 clues.
Yes.
Do you recall which clue that was?
It was the improper turn.
And 1 out of 8, is that a pass or a fail under your training?
A 1 out of 8 would be a pass.
And on the one leg stand test, you said you observed 0 out of 4?
Correct.
Which is obviously a pass?
Correct.
So the only field sobriety test that you say that Mr. Morales failed is the horizontal gaze nystagmus test.
Yes.
Which is what you said on the camera would be because of his eyes, right?
Yes.
Now, in the horizontal gaze nystagmus test, you're looking for specifically 3 clues and whether it applies to each eye, correct?
6 total clues, yes, 3 in each eye.
And what are those 3 clues that you're looking for in each eye?
In each eye, it would be lack of smooth pursuit, on nystagmus at maximum deviation, and then onset of nystagmus prior to a 45-degree.
And for each of those tests, you have a specific process that involves you holding your finger or another focus item that you're asking people to look at and moving that in a certain pattern across their eye, correct?
Yes.
And were you trained in your police academy training specifically how to do that stylus motion to look for the nystagmus?
Yes.
Let's start with the first clue you said you were looking for. Which would be lack of smooth pursuit. Can you describe exactly what you do to check for lack of smooth pursuit?
While checking for lack of smooth pursuit in each eye, we go back and forth both times. Excuse me, we go across left and right 2 times each, checking twice essentially. And then we're looking at the eye to see if it's following smoothly or if it's like lurching across, it's not following smoothly essentially. The finger is approximately 18 inches away from the face, going at a smooth pace across left and right.
You say a smooth pace, left or right. How fast do you move your finger?
At a smooth pace, easily to track. I'm not sure how to answer that.
Well, I am looking at the training materials from the National Highway and Traffic Safety Administration. And I have the document that will be moved into, I'll ask to be marked as Defense Exhibit 1 when I'm done. But can you read, first of all, the portion that I have marked with an X? May I approach, Judge?
Your Honor, I'm going to have to object. Foundation, we don't know which version of the National Highway Institute training he's using.
I've provided it to the state in advance. Specifically, I'm looking at page 244 of the document under the clues of the horizontal gaze nystagmus test and the process that should be applied.
If I heard his objection correctly, maybe I did not, that he was objecting because because of the foundation as to what Deputy Carroll was instructed or learned under. Is that correct?
That is correct, Your Honor.
Okay.
Sustained.
Deputy Carroll, what training were you provided regarding field sobriety testing?
It would be through the Wisconsin DOJ, what Northwood Tech Academy puts together as a curriculum. I believe all their course material is on WileyNet.
Okay, I just had a hard time hearing or understanding what you said. The other course materials on what net?
WileyNet, it's WILE.net, I believe.
Okay, thank you.
Okay, friends, once again, I'm going to try to bump us past the
We
quiet
know
parts
because
here.
I need to tell you, if you were playing video at a next
Never
hearing,
mind.
you have to ask for more time where it needs to be reset. This was only set for a half an hour.
Understood, Your Honor.
Deputy, are you aware of whether the training you received complies with the DH Department of Highway Safety, National Highway and Safety Transit Association guidelines?
I truthfully can't recall at this moment, no.
And you can't recall how fast you're supposed to move your finger when you're detecting lack of smooth pursuit in the eyes?
I had said before smoothly, but if we're going off of the DHSTA, I can't recall their parameter, no.
And you can't recall whether your training complied with those guidelines?
At this moment, no, I don't remember what the academy put on.
Does your office still have access to the training materials?
I'm not sure.
Okay. Regarding the, so you're supposed to do 2 passes to the left, back to middle, to the right, back to middle, again to the left, and again to the right.
Yes.
In your opinion, or in your training, do you believe that the speed you move your finger matters?
Yes.
Okay, but you don't know how fast you're supposed to move your finger?
Again, I moved at a smooth speed.
Yes, a smooth speed, but whether that smooth speed took 1 second or 5 seconds, you don't know what's appropriate.
I can't remember the exact time, no.
Okay. Moving on to the second clue you were looking for, sustained nystagmus at maximum deviation. What exactly are you looking for that clue?
Sustained nystagmus at max deviation would be the involuntary movement of the eye when the eye is farthermost to the outer corner of the eye.
Mm-hmm.
So it would be the jerkiness back and forth at that position.
And what does the sustained mean?
Excuse me?
You're looking for sustained nystagmus at maximum deviation. What does sustained mean?
It would be continuous.
For how long?
I can't remember the exact amount of time off the top of my head.
But you are supposed to pause and look for whether the nystagmus is sustained, not just whether you observed it, correct?
Correct.
And you don't know how long you're supposed to be looking for to make it a clue?
Off the top of my head, I can't remember right now.
Okay. I am going to play what will be marked as Exhibit 1, and I'm going to go, I believe, to 5 minutes and 50 seconds. Actually, I'm just going to start from the beginning of the horizontal gaze nystagmus test, which would be at roughly 5 minutes and 30 seconds. I'm going to start from 5 minutes and 29 seconds.
Otherwise, I'm not going to be able to look that far.
Okay.
I've had it.
Yeah. Just follow it as best you can. Okay. All right. We're going to begin. Don't move your head. Don't move move your head. You're good. You're doing good. You're doing good. Keep going. Okay.
Now, I just watched you do 2 complete passes, left, right, left, right. That was you checking for the first clue, correct?
Lack of smooth pursuit.
And now you are about to begin checking for sustained nystagmus at maximum deviation, correct?
Yes, I believe so.
Keep going. 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 You're doing good. Keep going.
Now, I paused at 5 minutes and 52 seconds. Your finger just reached the maximum deviation, correct?
I believe so.
That's for the next.
And you began moving it back at 5 minutes and 55 seconds, correct?
I can't see the time from where I'm sitting at, to be
Oh.
honest.
Judge, would the court take judicial notice that I paused it at 5 minutes and 55 seconds?
If that's what you're telling me, because I can't see it either.
I am telling you that I have paused it at 5 minutes and 55 seconds. You can't, can you see it?
I can see it from
Okay.
here.
Yeah,
And
I have
that would be,
screens blocking me.
and at that point, Deputy, your finger has begun to move back. So we're no longer looking for sustained nystagmus, correct? And now you're going to move to the other eye, correct?
Yes.
I'm going to play the video again and watch.
Yep, I got you. Keep going. You see that or no?
If I move my head, I could see.
Now, at this point, Mr. Morales began talking to you, correct? So the test was interrupted.
For a short couple seconds.
Did you do it again?
I can't remember.
We'll play the video.
Okay, here, I'll come back a little bit. Look at my finger.
That's the furthest I can see.
Okay.
Right there.
You're good. We're gonna do it one more time. Keep looking, keep looking, keep looking. Okay. Keep looking, keep looking, keep looking, keep looking. Good.
Was that you testing for sustained nystagmus at maximum deviation?
Yes.
Did you even pause your finger at maximum deviation on those 2 passes?
I would have to go back and watch it again, but it
You
looked
want
like
to?
it paused.
I'll reset the video to 6 minutes and 4 seconds.
See it,
Okay. Here, I'll come back a little bit. Look at my finger.
That's the furthest I can see.
Okay.
Right there.
You're good. We're gonna do it one more time. Keep looking, keep looking, keep looking. Okay. Keep looking, keep looking, keep looking, keep looking. Good.
Did you even pause your finger at maximum deviation on those 2 passes?
It appeared it paused, yes.
For how long?
I didn't count.
And what is the purpose of looking for sustained nystagmus at maximum deviation?
The purpose of looking for
Yes. What is
sustained
the reasoning behind why that is a sign of intoxication?
I can't testify to that. I'm not sure.
So you don't know the reason, you don't know how long you're supposed to pause at maximum deviation, and you don't even know how long you paused for.
I don't know the exact science behind it right now.
What were you trained?
Can't remember which course material we were taught on.
Okay. And you know it's supposed to be sustained nystagmus, but you don't know how long to wait for or why. Is that true? Am I
know you're
accurately
supposed to
stating your
pause.
testimony?
True.
Okay. And what is the third clue that you're looking for?
It would be nystagmus prior to a 45 deviation.
And what do you do to look for nystagmus prior to 45 deviation?
Again, it would be the left and right passes.
What are you looking for?
Involuntary movement of the eye. Essentially the eye moving, like wiggling back and forth, not like sitting still.
That's your description of the test?
No. It would be at the 45-degree angle. It'd be prior to that if the eye was wiggling.
Okay. At the 45-degree angle prior to that if the eye was wiggling.
Yes.
And how do you look for that?
By doing the left and right passes in each eye twice and looking at looking at the subject's eyes, looking for the movement of the eye.
And you move your finger in left and right passes?
Yes.
Anything more specific than that?
No.
Do you know how fast you're supposed to move your fingers?
Again, I don't know how fast I'm supposed to move my fingers. I move it at a smooth rate.
Are you trained in that?
Yes.
So you were trained as far as how fast to move your fingers. You just can't recall what you were trained?
I can't remember the exact wording, no.
Okay. Can you tell me whether your application of that test on January 1st, 2026 complied with that training?
To my recollection, yes.
Is it important to move your fingers slowly so that you can see the nystagmus?
Yes.
Okay. I'm going to jump to, I'm already there. So right after you did the test for sustained nystagmus at maximum deviation, you began to test for the third clue?
Yes.
I'm going to play the video again from 6 minutes and 19 seconds.
All right, 2 more times in each eye here. Perfect. Perfect. Good. Last one. Good. Now we're gonna go straight up.
And I've paused it again at 6 minutes and 34 seconds. And you just completed that test, correct?
Yes.
So 4 passes, left, right, and it took 15 seconds total.
I didn't keep track of the time again, but if that's.
Yeah, I paused
on
it
the
at 6
video,
minutes, 34 seconds, and you're done in that video.
Okay, yes.
Okay. And it's your belief that on January 1st, 2026, you observed nystagmus prior to 45 degrees?
Yes.
Were you familiar with Mr. Morales at all prior to this day?
No, I had never met Mr. Morales before.
So you weren't familiar with his speech patterns?
It was the first time I had met him, so no.
Okay. Did you have any interaction with him beyond what was recorded here on this video?
If the recording starts at the start of this and ends after he's dropped off at the jail, then no, I did not have any further contact.
Let's just go from the first interaction with Mr. Morales until you made the arrest decision. Was there any other interaction with Mr. Morales that we didn't play here today that made a decision in your decision to arrest him?
No.
It's obvious he became kind of flustered when you began talking about how much he had to drink today, right?
He immediately jumped to saying he didn't deserve a DOI, so.
And his speech started getting a little stuttering at that point, right?
I can't remember exactly when it happened. I thought it was immediate.
Well, I'm going to play from the beginning quick. This is you in your car, right? You haven't had any interaction with Mr. Morales yet?
Yes, I believe so.
Hello. You okay?
How's it going? Yep, I got someone on the way.
All righty. Your car's wheels are still spinning. Good.
I guess I didn't realize that. Thanks for letting me know.
Yeah. What's your name, man?
I'm Antonio.
Okay. Don't worry. Do you have a driver's license, Antonio?
Yes, I do.
All righty.
Is that what you're calling slurred?
You asked if it was stuttered before, and he stuttered after I told him his wheel was moving a couple times.
That's what you're using as a sign of intoxication?
The stuttering, no. The slurred speech, yes.
Is the speech that we just watched there prior to 55 seconds on the video, is that what you're considering slurred?
At that point, not extremely bad, no.
Okay. We're going to continue to play. It's at 55 seconds now.
You're in there pretty good, my man.
Yes, I am.
You okay?
Yep, I'm like five miles away from home.
I gotcha. Where do you stay at, Antonio?
It's like between Webster and Siren.
Oh, okay. Like on County Road D or where at?
It's right off of County Road D.
Okay. Where are you coming from, Antonio?
I'm coming from all the way over in Luck, Wisconsin.
Really?
Yeah.
Why are you coming from all the way over there?
Well, that's where it's a long story. My house burnt down.
Oh, man. I'm sorry about that.
I'd rather not explain the whole situation.
No, you don't have to. You don't have to.
But yeah, this is where I'm staying right now. And
okay. That's fine. Okay. How much you had to drink?
It's New Year's, so I've had a couple.
Couple? Okay.
And I'm being honest,
I don't think I deserve a DUI
Okay.
because dude, I'm living.
Paused it again at 1 minute and 56 seconds. Obviously, Mr. Morales started to get a little bit more flustered after you brought up drinking, correct?
I don't know if that's what he was feeling, but it seems like he was being defensive.
His
Yes.
speech pattern changed once you started bringing up alcohol, correct?
It looks like it, yes.
Okay. Prior to that, it did not appear that he was slurring, correct?
When he said County Road D, I picked up a little bit of a slur there, yes.
Okay. I have no further questions for the deputy.
Mr. Vila?
No further questions, Your Honor.
All right, you may step down. Thank you. Any other witnesses?
No, Your Honor.
Any witnesses?
No, Your Honor.
I'm going to ask for written argument. Yay!
Your
Because
Honor.
I have 0 time, so.
Your Honor, I am going to move into evidence the document that I've included on this flash drive, the National Highway and Transportation Safety Administration guidelines on the field sobriety tests. I'm going to move it in as a written treatise. Take it for what it's worth. This officer apparently doesn't remember whether he was trained on that or not, but I do believe it's relevant to the propriety of the horizontal gaze nystagmus test, and I will make references to it in my written argument.
All right. And do you have an objection to that, Mr. Vila?
No, Your Honor.
Then it is received as a treatise. Written arguments due by May 8th, simultaneous. And then because this, well, your state would get a rebuttal.
I don't think it's going to take me that long, Judge, and I think the fair thing to do is just to have me submit an argument and the state to rebut it.
Excellent. Can you do yours by this Friday, or is that too short?
I can do it by this Friday, Judge.
You can have more time if you want.
Why don't you, giving me till
give-
Monday isn't going to matter because I'm going to be busy all weekend, but
Well, I'll give you until Tuesday, the 5th,
sounds good, Judge.
and then I will give the state until the 12th. All right. And get another date set. Well, you're going to be here June 11th, so let's just do June 11th, 11:15. As a status or just a status. Yeah, that's enough time. All right. So we'll see you then. You can come get your notice, Mr. Morales, and then you are free to leave.
Sounds good, Your Honor.
So Nina just said in the comments, I will say I find the eye test the least convincing indicator. I would tend to agree. I mean, Mrs. TCF is a chronic migraine sufferer, and just because of that, she has nystagmus. So she would not pass a field sobriety being stone cold sober based on that criteria. So yeah, it's not an overly convincing indicator. It's something that a lot of people have an issue with. So there you go. It's unfortunate that we're not going to hear the result of this because they ran long, but I still think it was worth watching and listening to. Because personally, I rather enjoyed listening to that lawyer kind of pick it apart a little bit. I know some of you found him annoying. I think he did a good job. Texas, Judge West.
Good morning. Are you Caleb Laskowski? No. And will your client waive the formal reading of the motion?
Yeah, absolutely will, Your Honor.
Get that for Texas. Mr. Laskowski, in cause number 21-37917, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 3rd of 2022 for the offense of evading detention with a motor vehicle. And that was a 5-year deferred probation. Is that correct?
Yes, ma'am.
The motion alleges that you violated your probation. Count 1 alleges that you committed the offense of possession of a controlled substance February 16th of 2022 in Hardin County, Texas. And is that true or not true?
True.
Count 2 alleges that you committed the, again, the offense of possession of a controlled substance on February 16th, 2022 in Hardin County, Texas. And is that true or not true?
True.
Count 3 alleges that you provided a urine sample on March 29th of 2022 that tested positive for methamphetamines, amphetamines, and benzodiazepine. And is that true or not true?
True.
Count 4 alleges that you provided a urine sample April 14th of 2022 that tested positive for methamphetamines and benzodiazepine. Is that true or not true?
True.
And then count 5 alleges that you were behind in your court assessed fees as of April 13th of 2022 in the amount of $315. And is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before, excuse me, before you signed these, did you go over them with Mr. Crocker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection, states 1.
It's admitted. Is there any evidence that Mr. Liskowski is not competent?
None, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find this counts true. Find sufficient evidence to revoke your probation. And at this time, also find sufficient evidence to find you guilty. And at this time, find you guilty of evading detention with a motor vehicle. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed. And so you have waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Crocker.
All right.
All right, good luck to you, sir. You can go back to the bailiff. Thank you for being here.
Thank you, Ms. Smith. Yes, sir.
All right.
Steve, Mr. Brian Lane, you've got Heyman Brandon.
Yes, ma'am. And I need to bring you.
Well, he's here, so we'll,
Hold on, Derek.
you can go ahead and bring him.
What's that, Judge?
You can bring him.
Oh.
Good morning. Are you Heyman Brandon?
Yes, ma'am.
And this is 21-36605. And it looks like, number 1, Mr. Brandon is charged with first-degree felony offense of murder. And Dr. Rapon was requested to do a competency evaluation. I don't know that we've been back since then. We received that report February 12th.
What?
Over here, February 24th.
All right, so I've already made that
Found him
finding.
competent.
All right, so what's the announcement?
The announcement, Your Honor, is I'm respectfully requesting one more continuance. What I think, after talking with the state, is that we may eventually, at the next setting, request a bench trial. And we're moving into an insanity. I need an insanity valuation at the time of the offense. So I've got with Dr. Rapon. I'm supposed to meet with him.
Okay.
I just need a little time to get that. The state, after I get that, then we'll move forward and
Okay.
yeah.
Do you think he can get that done in 30 days? He's already done the competency, I would
Well-
think he would be able to.
When he came back from the state hospital, when he was, deemed competent, I called Dr. Rapon. Dr. Rapon kind of jumped the gun a little bit and thought I was talking about a competency. I already got a competency from, went out and did a competency.
Right.
And then billed me. But then, so I was like, it's like, hang on a second.
Okay.
So he's making an appointment with me. So I anticipate next couple of weeks, I'll be to him and he'll maybe.
We'll do 30 days, and if you don't have that back, let us know right before that court date, and we can reset it without you guys having to come here if he's in the middle of getting that report ready.
Yes, ma'am.
Okay, all right, you can go back with the bailiff, Mr. Brandon.
Right now, yeah.
See, Mr. Kevin Lane,
Yes, Sean.
you've got Ahmad LeBlanc.
He's in custody. What is this? How much?
Ms. Melfino, Ahmad LeBlanc.
Sitting here thinking I didn't notice a nice young new probation officer. Moderator and.
All right, are you Ahmad LeBlanc?
Yes, ma'am.
And Mr. LeBlanc was previously in court, entered pleas of true to counts 1, 2, and 3 in a motion to adjudicate and on probation for possession of a controlled substance, first degree felony. Hold on, that's not right. On probation for aggravated assault. New allegation is a possession of a controlled substance in Chambers County. And I've received the updated report. It was unagreed. Have you both had an opportunity to review the report?
Defense has none.
Have your any additions or corrections to the report?
None from defense.
Only any additional that Ms. Shagwa may have from the probation department, Your Honor.
And is this the one I believe Chambers County rejected the charge.
January 28th, Your Honor.
Okay.
Or refused it.
And so, Mr. Lane, you may proceed with argument.
Your Honor, we are asking the court to continue Mr. LeBlanc on probation. He's been in jail in this last time for about 58 days. He did test positive because he had smoked marijuana before he surrendered. He lives with his mother in Baytown. He has no children. He is working at Palmer Distributing, has been employed there for a while and working a forklift. He does do online classes with Southern New Hampshire University for computer training. He does 3D modeling, and that's when he was using with the THCA that he actually got, I think, out of California online that he had sent to him. He's done his community service hours. I think he's done 433 out of 400. I believe he's paid all of his fees. This was his only hiccup. He reported his arrest, I think, the next day after his arrest. And then when the warrant came out, which was, I think, January 20th, he hired me and then surrendered to the court. Your Honor, his mother is here. She's very, very much supportive of him, and I don't believe he'll use any more THC products. We are asking that the court, there is another plan to extend him for a year, drop program and another drug assessment, and we would ask that the court follow that alternative.
Ms. Melfino?
Judge, obviously the underlying offense involving a weapon is concerning. However, it looked like it was an issue amongst individuals who knew one another, probably involving some young women as well. Mr. LeBlanc does not have any criminal history. I hate to see him have felony, but he's also exposed to quite a bit on a revocation of this probation. I would defer to whatever Ms. Shagwell has to add, but I would ask that if he's continued, Judge, that he be extended and possibly have something a little bit more intensive than just the draw program.
Anything to add that's not in that updated report from probation?
No, ma'am.
So, I mean, Mr. LeBlanc, you've done so well. I mean, better than most you've done. So the fact that you've done all your community service, you paid your fees, you've reported like you're supposed to. Obviously you understand that you cannot use any type of THC program, THC in any form, whether it's legal here, legal in another state. It's if you test positive, there's no way for us to know if it's legal or not legal. And so you're not supposed to use it. If it's going to show positive in a drug screen, then you can't use it. You understand?
Yes, ma'am.
All right. So what I'm going to do is find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find this counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I think you've come a long way you're almost at the end of your probation. I'm going to continue you. I'm going to extend you for 1 year. Conditions are going to be that you'll be on the high, and I don't know if he'll still be in Harris County. And so whatever they have that's comparable to what I'm ordering is what you're going to have to do. You're going to be on the high medium caseload. You'll be, you'll be required to enroll in and pay for it and successfully complete the Texas Drug Education Offender Program. You'll obviously have to test negative. There's going to be a new substance abuse assessment done. If there's any issues that they find that you need more treatment than what we've already saying, then you'll be required to comply with whatever that is. Do you understand?
Yes, ma'am.
Okay. So this was an agreement. So you do have some rights to appeal. You can talk to Mr. Lane about that. And I need you guys to sign this, Mr. Lane, please. But you'll be released, and first thing you do is go to probation and make sure you get everything taken care of like you're supposed to, okay?
Yes, ma'am.
All right, good luck to you, sir.
Thank you.
So we're gonna need this though, once they all sign it, right? So you just, yeah, if y'all will get this, once you get the signatures, if you'll get it back to Kelly so she can get it.
All right, friends, I'm going to keep an eye on Judge West's court. We're in hour 3. Well, about 40 more minutes to go today. Let's go to Louisiana, checking on the board. Haven't been there in a while.
My name is Carolyn Stapleton. I'm at DOC headquarters with Mr. Pete Freeman, and we'll be joined by Jerry Ledoux. She'll be joining us by Zoom this morning. Is there anybody in the room with you today?
No, ma'am, not besides the officer that's outside the little box room I'm in.
Okay, at this time, we're going to introduce headquarters staff. Okay. All right. I'm going to read your revocation statement, okay, the reasons for your revocation, and then you're going to let me know whether you agree with it or not.
Want to get his questionnaire and we'll turn it over to Ms. Ledoux and she can read the violations.
Okay, it's hers. Got me up there. It's good. Okay, well, what we're going to do is we're going to ask you, do you have your questionnaire, sir?
Yes, ma'am.
Okay. And you agree with everything and you got your notification. So at this point, I'm going to turn it over to Ms. Ledoux.
Yes, ma'am.
Okay, minor difficulties at the moment. Just stand by.
Yes, ma'am.
Okay. Ms. Stapleton, if you want to go ahead and read out those revocations.
Sure. No problem. Okay. All right. So rule violations number 4, you committed the offenses of aggravated assault with a firearm and convicted felon in possession of a firearm evidenced by a warrant being issued by the Brewery Police Department on 12/31/2024. On 12/18/2025, in the 18th JDD under docket West Baton Rouge 251060, the subject's pending charge of aggravated assault with a firearm was ruled non pros by Judge Tanya Lurie. Do you agree or disagree with that?
I agree.
Huh?
Okay.
Okay. All right. Committed the offense of domestic abuse battery, evidenced by a warrant being issued for your arrest by the Port Allen Police Department on 3/4/2025. On 9/3/2025, in the 18th JDC under docket West Baton Rouge 250824, the subject's pending charge of domestic abuse battery child endangerment was ruled non pros by Judge Tanya Lurie. Do you plead guilty, not guilty, or guilty with a statement?
Not guilty, but can I still?
Yes, you can.
So far as the domestic abuse battery and the child endangerment, that was my baby's mother. She stood up in open court and let the judge and the DA know that she was drunk. That was Mardi Gras Day. It took place. She was drunk. She was the aggressor. I didn't do her anything. And so far as the other charges, her and the other girl, let the DA and the judge know that I had nothing to do with that. Now, who they told them it was, I don't know, but I had nothing to do with that.
Did you have a gun?
No, sir.
Well, why did witnesses say both of y'all had a gun?
I don't know why they say that, but I didn't have no gun. So I don't know if they told you that about me, they lied. Respectfully, I didn't have no gun. I know not to possess a firearm. I had nothing to do with that.
So that one, of course, you plead not guilty to also, both of them so far. Okay, you were arrested by the Baton Rouge Police Department on fugitive warrants for both Brewery Police Department and Port Allen Police Department on 4/16/2025. Guilty, well, not guilty or guilty with a statement.
Guilty with a statement. I was arrested in East Baton Rouge for the warrants in West Baton Rouge.
Okay. According to the warrant provided by the Brewery Police Department on 12/31/2024, you were in possession of a firearm in the commission of the offenses. Convicted felon in possession of a firearm and aggravated assault with a firearm. Guilty, not guilty, or guilty with a statement?
Not guilty, ma'am. That's why they dismissed the charges in court. If I had a firearm, they would. If I would have had a firearm in my possession, they wouldn't have dismissed the charges. You see, kind of understand what I'm saying, ma'am?
I know, but I read in the police report too that the person that there was another person that heard the gunshots, and they went out there, and in the exact location where you were and had been walking, they found 2 spent shell casings.
Ma'am, yes, ma'am. I understand what you're saying, but ma'am, listen, I did not possess no firearm. I'm 33. Ma'am, I've been on parole, as you can see, a long time. I know the do's and don'ts. One thing, if you look at my track record, I'm gonna take. If I'm wrong, I'm gonna admit. I'm gonna take my charge. I'm gonna take my time. I'm gonna do my time and go on about my way. This one here, ma'am, I went all the way because they really got me bad this time. If you look at my convictions, I take my time, continue on with my life, ma'am. I do. I have no problem owning up to what I've done. But this one,
Let me tell you something about that. I am looking at your record, and you're a 4th class offender, And here's the deal. Yeah, in 2022, you were charged with illegal carrying of weapons, firearms, dangerous instruments, and it was with drugs. Then you get out on good time, and you had a history of that. And in 2022, you had a second-degree battery charge. Very similar to what we're talking about right here today. So that was in 2022. And then you had Schedule 1 narcotics, 4/18/2022. And then you had Schedule 1 producing, manufacturing, distribution, possession with intent, 2022, narcotics. So, and I'm looking here on your probation record. You had a conviction 2011, all right? Then you get out on good time, 2014. 2015, revocation waiver was a technical. And then on 2015, you get a good time release again. 2016, again, you're incarcerated. So you were out a year, just kind of like right now, you've been out like a year. And so 2018, were released to supervision, good time parole. Then 2019, another time, revocation. And then 2021, good time parole, released to supervision. 2022, revocation. 2024, good time parole. And now we're here today.
Yes, ma'am. As I said, life been rough for me, ma'am. Life been rough. I'm not gonna deny it. I'm not gonna try to BS you. Life been rough, ma'am. It has. I'm not holding nobody else accountable for my past decisions. I'm taking full responsibility of that. Accountability.
You take full responsibility every year and a half. You get out and then boom, there's trouble.
I lost my mom back in the day. I went berserk. I lost it. I couldn't think straight. I do the best, regardless to what I may have done. I do the best I can to provide for my children. It's me and my baby mother. I play my role when it comes to my children. Life been hard. I have no explanation for it. But this one right here, this one, no ma'am, no ma'am. My past, as you see, I take my conviction and I go about it. But this one here, ma'am, no ma'am, no ma'am, no ma'am, no ma'am, no ma'am, no ma'am. And we went all the way. The judge dismissed our charges. They talked to whoever had something, my baby mama and the other person that had something to do with it. They told them the real, whatever that was, I don't know. But whoever said I had a gun, that's mistaken. I did not possess a firearm. Like, I don't know what else to tell you, ma'am. I'm not trying to sit here, lie to you, or BS you whatsoever. Like, I'm telling you the real. Like I say, my past, I took all my convictions. I didn't go all the way. Hey, I did it. I did it. This one here, ma'am, when I'm wrong, I'm a man. I'm a own up to it. With all due respect, man. As a man, if I'm wrong, if I made a decision, I'm gonna stand on side. That's what I did. But this one here, I gotta go down swinging because I didn't do anything.
Okay, let me ask you this. Okay, according to the statement, the police statement by Dominique Thomas, they took photographs of visible marks Thomas sustained as a result of the incident. Jackson fled the scene prior to police arrival in an unknown vehicle in an unknown direction. And it said Daryl Jackson committed the offense of domestic abuse, battery, child endangerment by pushing, kicking, and slapping the victim, Dominique Thomas, inside her residence. Her statement is that Thomas advised the incident began when Jackson arrived at her residence when she was not home and picked up their son Zane without her knowledge. When Jackson later returned the child to the resident, a verbal argument occurred. Thompson stated that Jackson became enraged, began pushing her throughout the house, kicking her and slapping her in the face. Thomas further stated that Jackson scratched her on her upper chest area. So she's the one that told everybody that you did those things to her and they took pictures.
Okay, and what, ma'am, that lady has an alcohol problem. That lady, when she gets drunk, she goes berserk. And when she seen that she got me in a lot of trouble, she came to court and told the judge, Your Honor, I was drunk. I was the aggressor. He didn't do me anything. Now maybe the scratch had came when I was trying to get out of the house and I pushed her off of me. She was tearing my shirts, wouldn't let me out of the house. So I maybe scratched her as I pushed her off of me trying to get out of the house. But yes, I came and I got my son. I got my son. I had my son all day. That's my junior. I wanted to see my baby. I got my son. I spent the day with him. We went out to eat. We went to the park. We did our father-son thing. And when I brought him back, that was so much of a problem for her. So once I'm putting him in his room, taking him to his room, let him know daddy be back. Ooh, here she come with the foolishness. So once she go to doing whatever she doing, as usual when she drunk, I'm trying to get out of the house. Man, go ahead. Please go ahead. That's the most I did. Yes, get her off of me to get out. Yes,
I'm going to pass the questions over to Mr. Pete Freeman.
Okay. Max, well, I got one more question for you. Okay, were you there when the incident went down? Between the two ladies that were supposed to fight over the laundry. Were you there?
Yes, sir. I was the peacemaker in the situation.
Am I gonna believe you? Because you told them at the preliminary hearing you wasn't even there.
I never told them that. The ladies themselves, you can call it
He was not present during the incident. Jackson advised that his ex-girlfriend is out of control.
Sir, ma'am, sir, I mean.
Okay, I have no further questions.
Okay, Ms. Ledoux.
Yes, we do have a memo attached to the file that has comments from Lakeisha Duncan indicating that she claims that the women turned to walk away, shots were fired. She believes it was an attempt to intimidate each other. She did not see who fired a gun, as both males had firearms.
Correct.
Okay, so I have no further questions. I stand ready to vote at the appropriate time.
Oh, we've got somebody. Oh, who's joining us? Dominique is going to join us. Dominique? You can go ahead and speak, ma'am.
You hear?
Yes, ma'am. Go ahead and speak.
Well, I just want to speak about this incident happened brutally. That has nothing to do with Daryl Jackson. He wasn't there when it started. He came because he was coming to the night, but it was between me and Lakeisha, and it was just her and DeQuincy Kane that was out there. DeQuincy Kane is the one that
Can't hear you, breaking up. Yeah, try to call on the phone.
They're going to try and call you on the phone.
Hello?
Yes, sir.
Okay, we're going, we got you on the phone now. It's gonna be hard for Ms. Ledoux to hear, but we can hear you very well. So go on and make your statement, what you want to tell us.
I was commenting on the situation that happened in Brooklyn between me and Lakeisha Bird.
Okay,
That situation, it had nothing to do with that. When it first started, he was not there. It was me, the Quincy, and the chief that was there. Daryl came later on. And once the stuff had already started to try to get me inside the house. He never came out there with a firearm. The only person that had a firearm was the Quincy King.
so why would you make the statement that he had a firearm? I mean, okay.
Well, I got another
What
statement.
about the slapping and stuff? Did he hit you?
You made a statement.
That was one of the drunk nights I had, and I don't really know what happened that night because I was intoxicated.
Gotcha. So you have any questions? Anybody, Ms. Ledoux, you got any questions? Man, don't be doing all that on the screen.
I apologize, man.
All right, but don't do that.
Yes, sir.
Okay. Any more questions? Okay.
Ready to vote? Okay, the case is mine. So, Mr. Jackson, based upon your prior history of numerous revocations, you're only usually out a year, maybe a year and a half, and then you're revoked. And you've done that again this time. You're a fourth felony offender, and also the domestic violence. Now, she says she didn't, but I mean, there's affidavits that she's accusing you of slapping her and coming back to the house with the child present. So, you know, that's her statement. And based upon that, I'm going to, we have law enforcement opposition. Let me see. My vote is going to be to revoke you today, based on past history and present accusations. Okay. Ms. Ledoux?
My vote by the preponderance of evidence, by police reports and witnesses, is to revoke parole and to encourage this offender to be placed in the Duluth domestic abuse battery program during his incarcerated period.
Very good.
And I concur. I find him in violation condition number 4 and number 5.
Okay, that concludes our interview today, and it's 9:16.
Revoked, probably to the surprise of no one. Let's do something different. Newaygo County, Michigan. This is Judge Robert Springstead.
All right, this is case number 2513603 FH, People versus Roberto Ailman. He's set for a probation violation hearing today. There's been a recommendation made that his initial guidelines were 0 to 17 months. He was originally sentenced to 270 days in jail. The recommendation is that he serve an additional 90 days for this probation violation, that he remain on probation after serving the jail sentence. And Mr. Walburn, do you adopt that recommendation as an offer in this case?
I do, Your Honor.
And Mr. Prysock, is that your understanding of the offer?
It is, Judge.
What does Mr. Ailman want to do?
Judge, you'll enter a plea to the 2 non-technical violations of use and possession of marijuana, and ask the court to follow the recommendation of probation department. I explained to him, court follows the agreement. It's going to be the end of his county time. Once he finishes his jail sentence, he knows he's going to be on probation. He also knows that if he violates again, there's probably no alternative but an MDOC sentence, unless there's a treatment option available, but he understands that, Judge, and with that being said, he'll enter his plea to the violations.
All right. Is that what you want to do, Mr. Allen?
Yes, Your Honor.
All right. Raise your right hand, please. Do you solemnly swear oath or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? You understand that the allegations here that you're placed on probation in this court for an 8-year felony offense of possession of a controlled substance less than 25 grams with double drug enhancement. You understand that?
Yes, Your Honor.
That you were sentenced on October 14, 2025. The allegation further is that you violated your probation while you were in the jail in a non-technical manner. Count 2 says that you violated condition number 1, that you not violate any criminal law of any unit of government. And the allegation is that on or about March 7th, that you violated Michigan state law when you were in possession of contraband marijuana dab pens while in the Whittle County Jail. You understand the allegations continue in count 2?
I do, Your Honor.
Count 3, another violation of condition number 1. And on the same date that you violated Michigan state law when you used or possessed contraband marijuana in the Whittle County Jail. You understand the allegations contained in count 3. There's an agreement in this case that you be sentenced to an additional 90 days in jail for this probation violation, which would bring you up to 360 days in jail. You understand that? Further, that you probation would be continued after that. You understand that? They'll probably take any good time that you may have earned from you. You understand that? All right. Is that your complete understanding of the plea agreement in this case? And subject to the plea agreement, how do you wish to plead? You understand that if I accept your guilty plea, that you're giving up, can I swear in?
Yes.
Okay. You understand that if I accept your guilty plea, you're giving up the right to contest these allegations at a hearing?
I do.
And you also understand that you're giving up the rights that you would have at that hearing. We've previously advised you of those rights in writing. And you signed the advice of rights form on April 7th. Did you read that document? Did you understand those rights? Do you also understand that you might be giving up the right to appeal any appealable issues you might have if you had a contested hearing and I found you guilty? You understand that you are giving up the right to appeal this conviction sentence, and if you wish to file an appeal, it would be by application for you to appeal in the Court of Appeals, and it's not an appeal by right. Has anyone threatened you to get you to make this plea? Has anyone promised you an outcome different than we placed on the record? Are you entering this plea of your own free will?
Yes, sir.
Understand that if I accept your guilty plea, you're giving up the right to later claim that this plea was not your choice. Do not give up your right to contest these allegations at a hearing and all the rights that you would have at that hearing. And do you affirm your guilty plea?
Yes, sir.
Is it true then that back on October 14, 2025, that you were placed, that you were sentenced and placed on probation in this court for the 8-year felony offense of possession of a narcotic or cocaine less than 25 grams with double drug enhancement?
Sure.
Was it also true that a condition of your probation was that you not violate any criminal law of any unit of government?
Sure.
Did you violate that condition of your probation on or about March 7th? You were an inmate in the Whittle County Jail. Did you have trustee status at that point?
Yes, sir.
And did you have possession of THC, dab pen, and or other marijuana as well?
Yes, sir.
And did you smoke or ingest that while an inmate in the Marion County Jail?
Yes, I did.
Where did you get those substances? You gotta be careful here because my inclination is to send you to prison. And if you do not tell me truthfully where that came from and how it happened, I'm not going along with this deal. You're going to prison.
I sold from out the window, sir. I sold from out the window.
Somebody threw those things to you out of a window. Right? Who did that? What's her name? Katie what? And what is her relationship to you? Girlfriend? All right. And you had some, you communicated with her somehow, asking her to do that. Is that correct? Okay. And she did. Right? Was it just this one time or had she done it before?
One time.
Is that the truth? I'm asking you that because the report indicates that on about March 7, 2026, about 8:20 at 8:20, 59 approximately 1:53 minutes into the call, you asked the female on the phone, can you do me one favor again? And she said, yeah, I got you. So that to me says that it probably happened more than one time. Because otherwise, well, how would she know what the favor was? And why would it be saying, do me that one favor again? So I'll ask you one last time. Was this the first time it happened or had it happened before? All right. Now, did you share or provide this contraband to any other inmates in there, or just keep it for yourself? Right. Why would you do this?
I was saying I have a drug problem, I guess.
Okay. Are the attorneys aware of any promises, threats, or inducements which have not been stated on the record?
No, Your Honor. None.
Is he competent to enter this plate?
Yes, Your Honor.
Does the court comply with the rule for taking the plea in the probation violation case?
They have, Your Honor. Court has.
The court does find the plea to be knowing, understanding, voluntary, and accurate. The parties wish to proceed to sentencing today?
Yes, Your Honor. We do, Judge.
Is the report timely made available to you?
It was, Your Honor. It was.
Mr. Price, I give you the opportunity to read the report and discuss it with Mr. Elman.
I have, Judge.
Do you have any additions, corrections, or challenges?
We do not.
Anything that you want the court to consider?
Well, he and I talked about this, and about him telling the court what happened, and how it happened, with the understanding that that's part of the rehabilitation process, part of what the court's looking for, to be honest with the court regarding his actions. He knows that, again, this is going to use up the rest of his county time with his 90 more days. And that, you know, MDOC will probably be the next stop. So he did come through today, did tell the court the truth as to what happened, and we're asking the court to follow the recommendation.
All right, Mr. Elman, have you had the opportunity to read the report and discuss it with Mr. Price? Do you have any additions, corrections, or challenges? Anything that you want the court to consider?
Just want to apologize for bringing you guys to this court. Really feel that I did myself and I let my family down. I let the jail down, the courts, and I'll take actions. I'll take responsibility for my actions.
Mr. Walburn, any additions, corrections, or challenges?
No, Your Honor.
Anything that you want the court to consider?
Nothing additional.
All right, the court recognizes that the initial advisory guidelines in this case would suggest a sentence between 0 and 17 months. The court's going to exercise my discretion, since consistent with those advisory guidelines, consistent with the agreement in this case, be the sentence of the court that this defendant served 360 days in the Nuevo County Jail. Our calculations indicate that you have 196 days credit. The PSI says you have 211 days credit. So we'll have to reconcile those two numbers, but you'll get credit for the time that you spent in jail up until today. So we'll figure out what exactly that is and what the discrepancy is between our calculations and DOC's calculations, but you get credit for that. You are going to remain on probation, and as your attorney indicated, if there's any violations of probation, next stop is Britney. You do have the right to make applications and if you appeal your conviction and sentence. If you can have a court attorney, the court attorney represent you on the appeal request for lawyer must file with court within 42 days.
Judge, could you repeat Katie's last name?
I didn't write it down. Mr. Elman, what's Katie's last name again?
And then I saw Jonathan
Dutler.
That's, yeah.
Dutler. Dutler. Okay, thank you. The court reporter.
The status count.
Yeah.
And
The
so
final.
All right, friends, let's head back to Judge West's court and we will finish our morning there.
Good morning. Are you Paul Nelson?
Yes.
And will your client waive the formal reading of the indictment in each of the cases?
Yes, Your Honor.
Mr. Nelson, in cause number 23 DCCR 1786, you're charged with the third-degree felony offense of possession of child pornography from January 13th of 2021. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with?
Yes.
And then in cause number 23 DCCR 1787, you are also charged with the third-degree felony offense of possession of child pornography from January 13th of 2021. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with?
Yes.
In each of these cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with your attorney?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I'm required to ask everyone. State, excuse me. State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Nelson is not competent?
None, Judge.
All right, sir. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your pleas. Find sufficient evidence in each case to find you guilty. And at this time, in cause number 23, DCCR 1786, find you guilty, sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 23, DCCR 1787, find sufficient evidence to find you guilty. And at this time, find you guilty of possession of child pornography. Sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time, and also concurrently with Montgomery County cases. Is that correct?
Right.
They'll run concurrently with that as well. I'm handing you the trial court certifications. Those show that these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Judge Walker. All right, good luck to you, sir. You go back to the bailiff. Yes, sure.
We would ask that the court waive any court costs as he is indigent. If I need to, if the court needs me to inquire about that, I'm happy to, but he's been incarcerated for 2.5 years and he has zero dinero.
What are the typical court cost on a?
200 and something dollars plus this fee, plus that fee. So total in both cases, Your Honor, will be around $550.
What I'll do, let me make a notation and I'll get with Ms. Werner, the other clerk, and find out exactly with the process for that. And take into consideration that he's indigent, that you've relayed that, and I will let you know exactly how that works and if we can do it. Do you have any issue with regard to that?
I'll defer to the court on that issue.
Okay, thanks, Ms. French. All right, you can go back to the bailiff. Yes, sir.
Have a good day.
You'll make a note on me on that.
All right, friends, that will do it for this morning. We will be back for Sidebar tonight, 8 p.m. Eastern, 5 p.m. Pacific. Do join us for that. We're going to dig into that case that we saw in Judge Prill's court yesterday with the woman who was caregiving for her mother but managed to steal her mother's money. So do check that out tonight right here on this channel. And we'll be back obviously tomorrow, 9 a.m. Eastern, 6 a.m. Pacific. So join us then. I hope you all had fun. Thank you to everybody for helping out with the Super Chat goal today. We will Dr. Seuss the intro and outro tomorrow, so that should be fun. Go have yourselves a good day. Take care. God bless.